for the stream to fire up across the internet. If you're not a regular of the program, you may not know this, but we do multi-stream on a number of different platforms, including YouTube and Facebook and Twitch and Periscope and all of them. So you can check us out over there. We always like to make sure that things are moving before we get going here. Let's take a look and confirm that it is, and it looks like we are live. So let's get going. Hello, everybody. Welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful, sunny Scottsdale, Arizona, where my team and I, over the course of many years, have helped to represent thousands of good people facing criminal charges. Sometimes in our lives, people have little bumps in the road, and we want to help them get things back on track. And over the course of our time in practice, we have seen a lot of problems with our criminal justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in doing justice, and it all starts with the politicians, the people at the top, the ones who write the rules, pass the laws that they expect us to follow, but they sometimes don't do such a good job themselves. And so that's why we started this program. It's called Watching the Watchers, so that we can watch them. We want to shine the big, beautiful spotlight of transparency and accountability down upon the justice system so that we can clean it up just a little bit. And that's why we're so happy that you are with us here today, because with your voice, we can see some serious momentum. Now, today, we're going to be talking about those very politicians that we say, sometimes they do things, good, sometimes not so good. More often it's the latter. We're going to be diving into the election news. We spent a lot of time on this channel talking about what is going on. Today's been a very busy day in the Supreme Court. Literally a couple hours ago, a new order came down from the Supreme Court, which ruined all of my show prep, but that's all right. We're going to be able to make some quick adjustments on it, and I want to update you on what's going on because there is a lot of activity here today. First, we're going to be talking about Senator Ted Cruz. He has made an offer to conduct oral arguments should cases get admitted into the Supreme Court. We're going to see if that happens. We also are going to review a little bit of the Constitution, and we're going to talk about Article 2, what some of the powers of the Supreme Court are, because there's a lot of cases there in front of the Supreme Court. We're going to talk about this new deadline that was just instituted by Judge Alito. There was a new ruling that came out today about that very case. We're going to talk about that. And then again, another Supreme Court case was filed this morning or late last night, which is filed on behalf of the state of Texas against 4 other states. So we want to talk about that one and break down that lawsuit, that petition for certiorari, and more. There's a lot to dive into today. So I want to invite you, if you're not a regular of the program, now's a good time to have you come on and hit that subscribe button, because we do go live at this time every day of the week. We're not going to be here Thursday, Friday this week. I'm going to be out at a conference, but we're going to be back next week, and it's every day at this time. We want you to be a part of the show. As a reminder, a quick share from you or a thumbs up would be very helpful. It helps us show this video to more people. The algorithm really appreciates that. And as a reminder, I'm about to go through some slides here, and all of those slides are going to be available for you if you would like to download them. They're free. You can just get them in our Discord server. The link is in the description. And as I'm going through this presentation, Miss Faith is going to be clipping any super chats or any pertinent questions that are related to the things that we're talking about. We're going to save those for the end of the program, which we will switch over to the live chat, and then we'll answer those questions. So let's get into it. Now, as I said, spent most of the afternoon doing some show preparation, and things changed a little bit, as they can do when you're covering the news. And so I just turned this on over here on Twitter, and what we can see is that the Supreme Court denies the request to stop the certification of the Pennsylvania vote. And this is the Kelly case that we've been covering here on this channel for some time. You can see here there's an order that says, in the pending case of Mike Kelly versus the Pennsylvania, the application for injunctive relief presented to Justice Alito and by him referred to the court is denied. What does that mean? Well, we're going to talk about it. You see some other responses, some other reactions here. Kimberly Robinson is saying the GOP bid to stop the Pennsylvania from certifying its election. They're noting that there is no noted dissent. So some of the judges just haven't chimed in. Very, very simple, very one-sentence order, right? And apparently nobody's that's it. That's all we got. So this entire election is, sort of waiting for the Supreme Court to weigh in and give us some guidance on this stuff, and they just decline that. Now, my initial thoughts on that are, this is sort of one of those cases that is bringing up some interesting arguments. I have a lot of the Kelly case that we're going to go through here, but this is not. There's several other cases in front of the Supreme Court. So if this is going to be an indication of a trend, that's not so good for the Trump team. But just because they didn't hear this one particular case doesn't mean that the other cases are without merit. And so let's get into it today. I want to start by going through a little bit about Ted Cruz, because Ted Cruz is in the news a lot today. He has indicated that if a case does get in front of the Supreme Court, it's one that he's offering to go do the oral arguments for. So I want to talk about that, about his addition to the Trump, I would say, team or their efforts. And then we're going to break into some of the other more specific lawsuits, because in that Texas case, they were filing lawsuits against 4 separate states. And I want to go and explain what's going on in each one of those states and how do they connect all of them together. It's a Texas case, so it's kind of a Texas Ted Cruz show today. So buckle up. All right, let's get into it. Now, starting back on December 1st, Ted Cruz originally had said that the Pennsylvania Supreme Court should hear the emergency appeal on the Pennsylvania election challenge. This is from his Twitter account. He posted this on December 1st at 4 p.m. And he's talking specifically about this case, the case that just got rejected by the Supreme Court. In particular, it's the Kelly case. We're going to talk about that. It says here he wanted to address this issue because the Pennsylvania legislature on the Pennsylvania case allowed a universal mail-in ballot without approval from the Pennsylvania Constitution. And this was his original letter. I'm going through this to just give you a little bit of a backdrop on what's going on. He says there is a strong likelihood that the state Supreme Court decision violates the federal Constitution, and he's asking that the Supreme Court get involved. Now, this was a letter he sent. We've already covered this. He's saying that 39% of Americans believe the election was rigged, and they lack standing before the election to bring a lawsuit. If they bring a lawsuit after the election, they've delayed too long, so it's a catch-22. If you're not familiar with kind of what's going on, you can go back and watch some of the prior shows, but we've been really, really going into this stuff, and this was the case that we were following. And just yesterday, Ted Cruz came out and he said, if the SCOTUS grants, which is the Supreme Court of the United States, if they grant certification in the Pennsylvania election case, I have told the petitioners I will stand ready to present the oral argument. And of course, that didn't happen. He was talking about the Kelly case. We just learned a couple hours ago, Judge Alito from the Supreme Court and the rest of the judges presumably heard or read the case, read the petition, and then rejected that. So they're saying we're not going to hear that right now. So as it stands currently, it's looking like Ted Cruz is not going to be called upon to go in front of the Supreme Court. But let's go through the rest of his statement, because he may actually be in front of the Supreme Court at some time. Now, he says here, because of the importance of the legal issues presented, I've publicly urged SCOTUS to hear the case brought by Congressman Mike Kelly, congressional candidates Sean Parnell, and state rep candidate Wanda Logan, challenging the Constitution of Pennsylvania and the election results in Pennsylvania. He says, petitioner's legal team has asked me whether I'd be willing to argue. I have agreed, told them that yes, if the court takes the appeal, I will stand ready to present the oral argument. As I said last week, the bitter division and the acrimony we see across the nation needs resolution. I believe SCOTUS has a responsibility to the American people to ensure within its powers that we are following the law and following the Constitution. And I agree with that. My inclination here has been for a long time that a lot of these lower level courts, they're interesting, they're relevant, they're pertinent. The fact that Trump's not winning them isn't particularly good news, but it kind of doesn't matter. The one that really ultimately matters is the Supreme Court. As long as you can, make the playoffs and get to the Super Bowl, that's what matters. It doesn't matter what your record is in the preseason. It just matters, how do you perform now and what is the final outcome of the final game? And that is what we've been spending a lot of time focusing on. And now a lot of the cases that are bubbling up around the country are getting to the point where they're knocking on the Supreme Court door, and in large part because of some of the deadlines coming up. Today, as we know, is the Safe Harbor Provision Day. Many people were speculating that that is what Judge Alito and the Supremes were focused on, because we saw over the weekend that Judge Alito moved up the deadline from, I think it was December 9th, which is tomorrow, to today, and then issued an order today on the Safe Harbor Provision deadline, so that should there be any activity, today would be the day where they could start making those maneuvers and not worry about the Safe Harbor Provision. Largely, I don't necessarily believe that Trump or his team have any problem with this stuff continuing to go on. We've covered it on their lawsuits here for a long time. The deadline that they are using is the January 6th deadline, which is the date where in Congress they're going to read the electoral votes. So between now and then, all the states are going to be certifying their results and submitting their electoral votes over into the House of Representatives on January 6th. That's when they'll open them up and read them and enter them into the record. And they're saying that is the day that really matters. Now, when I originally saw this from Ted Cruz, I was a little bit skeptical on it because he was saying, I'm ready and willing to go and make the argument here. Now, this is a guy who's very, very plugged into the Supreme Court, and he knows how this stuff works, and he knows how this stuff is probably going to play out. And I think he's probably pretty plugged in given the fact that he's a senator and he used to clerk on the Supreme Court. He's a law guy, and he's very, very plugged in. So my thought was, okay, is he being serious here, or does he know something that we don't know? Is he agreeing to go and make these oral arguments knowing that the SCOTUS is going to turn around and dismiss the case or actually deny the injunction, not grant certiorari so that they don't have to hear the case? So Ted Cruz could come out and say, sure, I'll do the oral arguments, knowing that he's never actually going to go and have to do any of the oral arguments. And so the question here was whether Ted Cruz is willing to do this for any arguments, or was it only that Pennsylvania case, because we just don't know what he's willing to do. But he is somebody who is highly skilled at this stuff. And so many people were very excited yesterday when he came out and said, I'm willing to do this. I'm ready. I'm really, put me in, coach. I'm ready to go. People were really, kind of jumping out of their seats saying, yes, this is our guy. This is who we need to go in and fight for our case. Now, a little bit about Ted Cruz. We've already covered some of this on a previous show. He has been around this stuff for a very, very long time. He was the Texas Solicitor General, the Texas Attorney General, who's appointed by Greg Abbott. He has been to the Supreme Court 9 times. He won 5 cases, lost 4. He authored 70 U.S. Supreme Court briefs, presented 43 oral arguments. 9 appearances before the court are the most of any practicing lawyer in Texas or the current member of Congress. He attended Harvard Law School, was a primary editor of the Harvard Law Review, and he was even a clerk to the court. So he clerked on the Fifth Circuit Court. He also clerked as the Chief Justice of the United States. For William Rehnquist, who was the Chief Justice of the United States in 1996. And so many people were very excited that he was sort of coming up off of the sidelines, off the bench, and willing to jump into the fray. Now, let's take a quick pause and let's sort of transition a little bit. We're still going to be talking about Ted Cruz. We're still going to be talking about other senators. And we're talking about the Supreme Court, and we're talking about an election lawsuit, but it's just a different one. It's not the one that just got rejected today. That was Kelly versus Pennsylvania. We're going to go into some of that here in a little bit, but I want to explain what else Ted Cruz is doing, because there's a lot going on, like I said. So just a few days ago, I think this was, I may have a date, very recently, all this stuff is happening basically on the fly. In the Supreme Court of the United States, once again, we have another filing from Ted Cruz and 10 other members of the United States Senate. So this one kind of flew under the radar, because yesterday when Ted Cruz was out there saying that he's offering to do the oral arguments, this was also happening. So this is the case of Mark Brnovich versus the DNC, the Democratic National Committee, and also they consolidated these 2 cases, the Arizona Republican Party versus the Democratic National Committee. So Mark Brnovich is our Attorney General here in the state of Arizona, and this is not this is a formal filing in front of the Supreme Court, but this is not they're not a party to this lawsuit. So they are briefing this case. Ted Cruz and 10 other Senate members of the United States Senate are filing as amici curiae in support of the petitioners. And that's a Latin phrase which means friends of the court. So Ted Cruz and 10 other members, they're filing as friends of the court in support of the petitioners, which means they're not a party to the lawsuit. They're not here. They weren't the ones who were harmed on this case. But they do recognize that, hey, we're senators, our states are involved. These issues in this situation are very important. And so as a friend of the court, we have a very strong vested interest in the outcome of this case. Therefore, court, we want to tell you what we think is going on and how this is, why this is so important to us. So another document, again, addressing voting rights, again, in front of the Supreme Court. I think we're going to see some more of this going on. So this case has been going on for quite some time. We're going to dive into it. Let me give you a background on who these senators are, because Ted Cruz said he's got 9 other companions here. Here we have Marsha Blackburn, Mike Braun, John Cornyn, Tom Cotton, James Einhoff. We got James Lankford, Mike Lee, Mitch McConnell, Rick Scott, and Tom Tillis. And they're concerned here about the aggressive wave of litigation aimed at furthering the expanding Section 2 of the Voting Rights Act. So, this one I don't want to spend too much time on, because I don't think this is as consequential as some of the other election lawsuits that are going on, but I just wanted to show you sort of how this process is unfolding and what it looks like, because I think this is instructive. So This is from the SCOTUS blog. If you have not checked it out and you're interested in any of the litigation, the SCOTUS blog has a very good summary of all the continuing election litigation that's going on around the country. And here is their synopsis for this case: Arizona Republican Party versus the DNC. Two issues: whether Arizona's out of precinct policy, which does not count the provisional ballots that were cast on person in election day, if they're outside of the voter's designated precinct, they're saying that does that violate Section 2 of the Voting Rights Act? And the other question is whether the Arizona ballot collection law, which permits only certain persons, so family members, household, mail carriers, election officials, to handle another person's completed ballot, early ballot, whether that violates the Voting Rights Act or the 15th Amendment. So you can see some of this stuff is kind of around the margins, I think. If we're going to be asking the question or answering the question either way in this, I'm not sure that it's going to change the outcome of the election. So if we're talking about, so specifically, we're talking about two different buckets of votes here in Arizona. We're talking about if you had a provisional ballot and you cast that in a precinct outside of your designated precinct, should that ballot count? Probably not enough to flip the race. Maybe it is, I don't know. Or the other question here is whether somebody else can handle your ballot for you. So we're talking about collecting ballots and those types of things. Whether somebody else who is not an election official, not a family member, household member, whether they can go and gather those ballots or do something to help you submit those ballots. So those two questions are pending in front of the Supreme Court, and the Supreme Court has said that we're going to hear on this issue. We've already accepted certiorari, and so this is sort of the opposite of what we were just talking about. The other one was going up to the Supreme Court in Kelly versus Pennsylvania. Supreme Court kicked that one down. No reason at all, no explanation, no dissent, nothing. Just nope, no good. Even though it was filed by a congressman and Senator Ted Cruz was pretty vocal in saying that this should go forward, it was dumped. Now, this other one was granted. So the one that Ted Cruz and the other 10 Senate members, this one is in front of the court. And you can see here some of the case history. On October 2nd, the petition was granted. The petition for writ of certiorari in 19-1258 is granted. These cases are consolidated. There's going to be 1 hour of oral arguments. And look at all this additional activity. So on November 11th, we have some additional documents filed. On November 13th. After the election, we have grants for additional time. And then in December, just a ton of activity. We have amicus briefs filed by the Election Integrity Project. We have amicus briefs filed by a number of different states: Ohio, Alabama, Arkansas, Georgia, Idaho, basically everybody. Cato Institute. We have American Constitutional Rights Union. We've got the Wisconsin Majority Leader, Scott Fitzgerald, and so on and so on and so on. And so down here at the very bottom, you can see, okay, there it is, amicus brief of Senator Ted Cruz and 10 other members of the U.S. Senate. So this is sort of what it looks like, and you can see how much time this is taking. So the petition here from October 2nd all the way through to December 7th, and the court is just gathering just mountains and mountains of statements and evidence and briefs and all sorts of material that they are going to be going through, and then that's going to help give them a ruling. They're going to be able to sort through all of that. They're going to just set it for an hour of oral arguments. They're going to have a couple questions. They're going to issue a ruling. So that's going to give us some indication as, what they want to do with Voting Rights Act. And largely, it's kind of an interesting case. It's one in which, like I said, I'm not sure that it's consequential to this particular election, but it is important. They're talking about sort of, equal opportunity versus equal outcome, which is a pretty big difference. On one side, you can say, all right, if a voting law gives everybody the same opportunity, that's all that we need. But if one of those has some sort of a disparate impact or disproportionately impacts somebody else versus, one demographic versus another demographic, then they're saying, okay, well, now that's a disparate treatment. Now that's sort of an unequal outcome, and we need to do things to modify that so that we have an equal outcome. So it's, it's kind of a nuanced, a little bit of a esoteric argument, as it were, but it's something that I think is pertinent. It's interesting, and this is still before the Supreme Court. So I wanted to sort of contrast that and show you what it looked like. One case was just dismissed this afternoon. The other one, which is about an election, is still in front of the Supreme Court. Now, let's go back over to the Mike Kelly case. In Mike Kelly, here we're looking at the original lawsuit, and I want to go through this because this was just denied, and I want to show you what the arguments were from the response. So Mike Kelly submitted this motion, his attorneys did. They submitted an emergency application for the writ of injunction pending the filing and the disposition of a petition for a writ of certiorari. So this was an emergency application. They filed this very quickly. They had not even submitted a petition for a writ of certiorari, meaning they haven't even asked the Supreme Court whether or not they will hear their case. They just said, listen, while you are considering this emergency application, you should also consider a petition for a writ of certiorari and let us into court, because this needs to happen so quickly. And as you see here, the applicants, the people who are filing the suit, are Mike Kelly and these other Congress people, these other people who are part of the government, versus the Commonwealth of Pennsylvania and, once again, Kathy Buchvar. And so they filed this emergency application. And if you remember, we spent some time talking about this yesterday. And take a look at all the activity that was going on. So on the right side, we have some of yesterday's activity. December 3rd, we had that response, in this case, 20A98 from Justice Alito. All of these documents were filed yesterday. So again, more amicus briefs and so on. And then today there was a flurry of activity. So on December 8th, we have motion for leave. We have a response to the application from the respondents who are opposing. Then we have the applicants, Mike Kelly, they filed their reply. So a lot of activity, and then another motion for leave. And then we got the order just today from the Supreme Court. So a lot of activity going on. We kind of want to make a little bit of sense of it. So let's do a quick reminder. Let's do a quick recap on what happened with the Kelly case. Then we're going to look at the response. So here in the case history, this is from the Supreme Court docket, there was a response. It was filed by the respondents in Pennsylvania. That's going to be the government. They were responding. They gave a number of reasons why the Supreme Court should not have granted that original emergency application. We want to go through those arguments because the court found them to be persuasive. They're going to probably find these arguments to be persuasive in other cases, so we want to understand what they are saying here. As a quick recap, this comes from the original lawsuit. So the slide I'm going to show you is from Mike Kelly's original lawsuit. These were his arguments. Let's take a look here. He says, in short, the Pennsylvania Supreme Court, we're talking about the Pennsylvania local state Supreme Court, is saying that the petitioners, they had no knowledge. Let me frame this out a little bit better. Let's go on to this slide so we can do a little bit of what's called procedural history. This is what the procedure looked like in this case. So the Mike Kelly lawsuit, here we have at the very bottom, we have Congressman Mike Kelly who's filing the lawsuit. And if you remember, this one originally went into the Pennsylvania Commonwealth Court, which is the lowest level court. So it's at the very bottom here. And at that time, there was a win. They actually were successful in that case. If you recall, we talked about it here. In the Pennsylvania Commonwealth Court, they found that there was a lot of merit to this lawsuit. They actually even said something to the effect of, this might be something that you win on the merits. This entire Act 77, all of this mail-in voting stuff, it might actually be unconstitutional. And so the lower level judge granted an injunction or started to put that stuff in place. But then the Pennsylvania Supreme Court, as you can see the next one up here, they just jumped right in and injected themselves into the process. So the Pennsylvania Supreme Court on their own came back and sort of butted their way into the Pennsylvania Commonwealth Court and said, nope, sorry, we're going to dismiss this case. We're just going to step right on in here. We're going to dismiss it. And sorry. And their basis for that dismissal was laches, which I have been critical of that opinion. I was talking to some people who are viewers of the program in the Discord last night, and we were sort of comparing and contrasting some of the other lawsuits. And so you can make the argument that Sidney Powell's lawsuits, I would say, are more susceptible to the laches defense, saying that her lawsuit should have been dismissed because Dominion's been around for a long time. But in Pennsylvania, remember, laches, which is the argument that you should have brought your lawsuit sooner, you waited too long, they couldn't have brought their suit because the law was still changing. Remember, there was a ton of litigation going on around Act 77. And so when the Pennsylvania Supreme Court turned around and said, we're going to dismiss this lawsuit based on laches, everybody was sort of scratching their heads on that. So that happened. And then now we just saw that Congressman Mike Kelly filed his lawsuit, filed that emergency application for that injunctive relief directly all the way up to the Supreme Court. So they just bypassed the Pennsylvania Supreme Court. They tried to sort of bootstrap a federal question issue onto the back of the underlying state claims, submitted all of that all the way up to the U.S. Supreme Court. And then today we just learned that the Supreme Court said, nope, sorry, no dice, we're not going to hear the case. So this is now basically a dead lawsuit. That being said, I do want to go through the response of what happened here. So let's remember what happened. The original lawsuit had a lot of problems with mail-in balloting and all that stuff. The lower level court said, yeah, I think it's pretty much a problem. Pennsylvania Supreme Court said, nope, get out of here on latches. Supreme Court of the United States just heard the response from the Democrats. This is what the response says. This is their argument as to why the Supreme Court should not have accepted the underlying case. Let's get into it. So this was submitted yesterday, and it is the opposition of the respondents, which is the government, to the emergency application for the writ of injunction pending the filing and disposition, so on and so forth. So it's just a response. And when we go through it, we're going to see that the petitioners here this is the argument from the Democrats. They're saying that the petitioners, or the Trump people, are asking this court to undertake one of the most dramatic, disruptive invocations of judicial power in the history of the republic. No court has ever issued an order nullifying a governor's certification, and for good reason. They're talking about Pandora's box. They're quoting another case, which I think is a good move here. They're saying that in this case of Wisconsin, so they're actually going to a battleground state. They're finding case law in Wisconsin, and they're saying this is what somebody, we're not saying this, Judge. This is what a judge in the state of Wisconsin happened to say about this, and specifically regarding elections. They're saying once the door is open to judicial invalidation of presidential election results, it will be awfully hard to close that door again. The loss of public trust in our constitutional order resulting from the exercise of this kind of judicial power would be incalculable. And so, again, it's just Pandora's box, right? If you open this thing, this can of worms, we're never going to be able to put the genie back in the bottle again. And let's go on. All right. So the main arguments I want to address and then comment on. The first one that they're talking about here is that the Pennsylvania lawsuit was filed too late. They're calling it unjustifiable delay. So this is their argument. They're saying Trump's people, they had an unjustifiable delay in filing the lawsuit. It supports the application of latches, and it also weighs against issuing the injunction. The Trump people waited for over a year. We're going to get on that in a minute. They waited over a year until after Act 77 passed, and then weeks after the election day to first bring their claims, this document says. Petitioners should not receive extraordinary relief under an unduly delaying a matter that created the very exigent circumstances that supposedly animate their rush to this court. All right. Let's talk about that. So they're saying here that they waited too long. So remember, once again, the new argument in front of the Supreme Court this time is different than what Mike Kelly's original lawsuit was talking about. Now it's saying that, yes, the underlying lawsuit, the arguments against Act 77, all of the problems with the constitutional structure in Pennsylvania, that's a good reason to be in court, but they have to get into the court in the first place. And because the Pennsylvania Supreme Court dumped the case based on latches, they needed to overcome that hurdle a little bit. They needed to say, nope, latches shouldn't apply. We got to get in front of the Supreme Court. Let us in, Judge. And they're responding to that argument. So they're saying latches was, in fact, appropriate. And here's my issue with that. They're saying that they waited too long to file a lawsuit. You can see it right here. They waited over a year to file the lawsuit, and then they waited weeks after Election Day. Well, if you've been a regular of this program, we've been talking about Pennsylvania lawsuits for a very long time, a very, very long time. One of the very first ones that we spoke about was back, I don't even know if this show was started in July. I think we were just starting watching The Watchers on a daily show, but you can see this is from the minute entries. The text is probably very small if you're watching this or listening to this on mobile. But what you can see here is the original lawsuit in Pennsylvania was filed by the Democrats, Pennsylvania Democratic Party. They filed in Commonwealth Court on July 10th, 2020. So even though the Act 77 passed in 2019, they were still fighting about this stuff as late as as early as July 10th, 2020. And you'll notice here, it went all the way up until October 28th. Remember, the election is November 3rd. The litigation was going on this entire time. Now, this is a separate case, okay? This is an entirely separate case. This is not Mike Kelly's lawsuit. This is somebody else's lawsuit. But they're making the argument that he should have brought his lawsuit himself personally a lot sooner. Well, my response to that would have been, listen, somebody else was suing on a lot of these issues, and there's no reason for us to go and join that person's claim. I guess I could have joined the claim, and maybe that would be the response to that. But my point is that nobody really knew what Act 77 was going to do or what it was going to mean, because as we can see here, there was a lot of activity going on. They applied, they filed an application for a stay in the U.S. Supreme Court. There was an opinion issued by the Pennsylvania Supreme Court. Then it went up to the United States Supreme Court. Then there were these motions to recuse Amy Coney Barrett. Then the Republican parties joined. Then it just went on and on and on until finally on October 28th, we learned from the Supreme Court that they denied the petition for certiorari. And that was just a few days before the election. And so, the response here is, okay, well, we didn't know what the Supreme Court was going to do. We didn't know what their holding was going to be. They could have come back out on October 28th and just said, yeah, you're right. That act is totally unconstitutional. We reviewed it. We decided we want to hear the case. We did. We reviewed it. It's gone. Dump it. You can't do any mail-in balloting. They could have done that, and they didn't. But they could have, and a lot of this stuff was still sort of in flux. So what I think it's sort of it's an unfair argument for them to go back and to tell the Trump team that you should have filed sooner because Act 77 was set in stone. We already knew what it was back in late 2019 because that's just not true. Nobody really knew what was going on. All of this stuff was being modified. COVID came around. They started moving, manipulating the election deadlines and waiving certain signatures and all sorts of stuff, which we're going to get into here. But the point is, they could not have brought a lawsuit because the litigation was so in flux. So this laches argument, especially out of Pennsylvania, I think is extremely weak. We don't know if the Supreme Court bought that part of it or not, but this is what the Democrats are saying, and the case is gone, so the Supreme Court might have latched onto this. We just don't know. All right, the second thing that they brought up as to why the Supreme Court should not hear the case is once again because they're talking about this idea of mass disenfranchisement. They're saying the public interest in avoiding the mass disenfranchisement of an entire state militates overwhelmingly against the request for relief. Judge Sutton explained, courts will not disrupt imminent elections absent a powerful reason to do so. Right? That comes from another case out of the Sixth Circuit. They're saying whatever it is called, that idea applies with exponentially greater force after an election has been completed and certified, especially where millions of people cast their ballots under truly extraordinary circumstances, sometimes risking their very health and safety to do so. Throwing the election results on a flimsy basis that would do violence to the Constitution and to the framers. All right, so, here a couple thoughts on that. Well, we're talking about disenfranchisement, and as we're going to get into the next lawsuit, which is Texas versus the 4 different states, the main argument there in a lot of these other lawsuits is, right now these courts are talking about, or this response, the Democrats' argument is that if you get rid of these votes, you are disenfranchising the voters. And that sort of makes sense on the face of it, right? If you're talking about only the 2020 election, and we're only talking about those ballots, and we're only talking about the presidency, and we have 7 million, mail-in ballots, and it's arguable whether or not the underlying law, Act 77, or some of the modifications, whether they are legal or not, and we just took that bucket in isolation and we said, okay, we're going to dump out 7 million votes. That sounds pretty bad, right? It feels wrong. I can agree with that. I'm an American. I want people to vote. I want to enfranchise people. I don't want to throw out a bunch of ballots. I don't want to, participate in a coup. I don't want to encourage the legislature to overturn the will of the people. We've never done that here. But we do want to follow the law. We do want to follow, we want to have order. And if the rules are on the books, the rules are on the books. And the best way to deal with a rule change that you want to see happen is to go through the formal mechanisms and change the rules officially according to the Constitution. You can't have a bunch of executives or secretaries of state or board of electors who just do whatever they want, kind of willy-nilly, just change the rules. That's not how you run a country. That's not how you run anything. You want to establish the rules, follow the rules. If you don't like the rules, change the rules, but follow the proper procedure to do that. And so what they're talking about here is just the 2020 bucket of votes. But what about all of the other elections? What about all of the other votes that have taken place? What about all of the other times for the last, 300 years, whenever Pennsylvania was first incorporated as a territory? For the entire history of that state, they have declined to make universal mail-in balloting a thing. This Act 77, they even wrote it into their Constitution, not Act 77, but the voting regulations are in their Constitution, as we're going to see. We're going to get there. But what about those people? What about those people that every single time modification to voting or this idea of expanding mail-in voting came up over the last 300 or so years, they declined to make those modifications? And you have to presume, with good reason, you have to presume that the voters did that on purpose. They didn't ever go through the constitutional mechanisms in order to make changes to how they run their elections. Somebody else did. Somebody else, a judge in Pennsylvania, a set of judges did. We're going to see in some of the other states that other people did who are not part of the legislature, which, as we know, the legislature has been delegated the authority to run the elections by the Constitution. So when you have a governor, when you have judges modifying the rules, that's in violation of the Constitution. That's what we're talking about here. Now, they're also talking about, it's funny here in this document, they're talking about courts will not disrupt imminent elections, which is ridiculous because, as we saw in 2020, everything leading up to November 3rd, they were disrupting elections all over the place. The Pennsylvania Supreme Court was. They modified the election date on their own. They changed it from November 3rd to November 6th. They found some bizarre power that they had under the Pennsylvania laws, and they said, yeah, because of COVID and the world's melting down, we're just going to go ahead on our own and change the rules. So don't give us that nonsense that you're not going to disrupt imminent elections. We know you are because you already did. There's a record of it. There's court documents. We've talked about it on the channel. Spent a lot of time covering it. They just changed it. So now they want to go back and say, oh, no, we can't change anything. And so now you are really, really stuck. You're totally stuck here because on the one hand, they don't want to impact or change any imminent elections. They don't want to disrupt imminent elections is what they're talking about, citing this Sixth Circuit case. Well, okay, so when are you supposed to file your lawsuits? I mean, does it have to be like 2 years before an election starts? Because in Pennsylvania, they just modified a bunch of election rules at the very last minute. And so if they would have filed their lawsuits before that date, they would have said, oh, no, we can't disrupt an imminent election. Even John Roberts did that. Remember, this case went up, not this particular case, but a Pennsylvania case, Pennsylvania versus Buchvar, or the Pennsylvania Democratic Party versus Buchvar, went up to the Supreme Court. John Roberts said, yeah, we don't want to interfere. So they split 4-4. If it's a 4-4 split, the lower court stands. The Supreme Court ruling stood. And so we have all these problems out of Pennsylvania because they didn't want to disrupt the imminent election. So you have no recourse if you want to file a lawsuit before the election. And you have no recourse after the fact either, because they're just going to tell you should have filed it sooner. So we don't know what the rationale on why the Supreme Court dumped this, but this is a weak argument in my mind. Apparently you can't sue at all. You can't file any lawsuits because if you file it too soon, they can't disrupt an imminent election. If you file it afterwards, you filed it too late, latches apply. Not too sound reasoning in my mind, but we don't know what the Supreme Court did. We don't know if they bought that argument or not. They just rejected certiorari. So let's go to the final portion of this initial document, this initial filing. They're saying that sometimes people were risking their very health and safety to go vote. And so they're making this pitch about grandma, poor grandma. She got up and she went down and she voted. And if you're going to disenfranchise her, what kind of a monster are you? You must be trying to undermine democracy. Well, once again, we're not talking about that. This act was all about Act 77, which was all about mail-in voting. And so really, the people here they're trying to make an argument on behalf of, they're saying, these people were put at risk. And if you now take away their vote, you put them at an unnecessary risk and they're not even getting the benefit of the vote. Well, that's not what we're talking about here. We're talking about mail-in voting and absentee voting. So did those people really put their lives at risk? I don't really think so. I think that the better argument would have been that if the voting had not been in place, then it would have endangered their lives. But it was in place because the Pennsylvania Supreme Court put it in place. So, I get where they're going with the argument. I just don't think it's particularly persuasive. But apparently the Supreme Court may have. And so the last point that they bring up is, of course, what I think is really the best argument, and probably the one that the Supreme Court did latch on, is that an injunction here, if the Supreme Court took action, would sow chaos and confusion across the nation while inflaming the baseless concerns. They're saying that the court reaches a case against a backdrop of unfounded claim. They've been repeatedly rejected by the state and the federal courts. The court should not plunge itself into a firestorm. And once again, we see this "we the people rule" line. We see that a lot out of these Democrats. Don't undermine the will of the people and all that stuff. Well, we're kind of arguing about that. We're kind of arguing whether or not the people really got to speak their voice in this election. That's what a lot of people have a lot of concerns about because of a lot of this malfeasance. And once again, they are referring back to these state and federal courts and saying, listen, Supreme Court, because these other lower courts dumped the case, you should too. The Supreme Court doesn't care about those other courts. Maybe they do. Maybe that's why they dumped this case, but it's the Supreme Court. They don't have to do what the state courts want to do. In fact, they often don't do what the state courts and the federal courts want to do. They set new rules that then trickle down to all of those different courts. So The reason why I said I think this is their best argument is because it's a political problem. It's a political question, and the court is not going to want to get involved in this stuff. Remember, we've talked about this a lot. The court's only real authority is about legitimacy. It stems from their legitimacy. The people think that the court has a lot of power because the court, for the history of our country, has been mostly a legitimate organization. And if they were to come back out and look like they were just handing the election to Trump, that might serve Trump well for the next 4 years if that, went to fruition. But after that, what happens? Many people would have a lot of real disdain for the court, and I think the court probably recognizes that. Now, we're going to see how this continues to play out. If I had to take a guess on this, I don't think this is going to be the last situation that we get out of the Supreme Court. I think there's going to be more cases that we see, more orders. Not particularly convinced that these are going to stop just because today is December 8th. I think there's a lot more pending there, and so we will see how that goes. So that's what's going on here. Those same arguments, I think, are going to be very repeatable. They're going to bring those arguments up again in basically every one of these lawsuits. So I wanted you to be familiar with what they are and offer some commentary on why I think they're maybe not so good, but the Supreme Court apparently did. Or maybe they have some other reason as to why they didn't accept it, but we will see. All right, so let's change gears a little bit. I want to talk about the new one. So again, there was a one gone from the Supreme Court today, and there's a new one. This is the state of Texas versus the Commonwealth of Pennsylvania, the state of Georgia, the state of Michigan, and the state of Wisconsin. And this is, again, in the U.S. Supreme Court. It was filed by the Attorney General of Texas. And the Attorney General of Texas, who's a special counsel, Lawrence Joseph, and Ken Paxton. And, this one is another good one. I want to detail a little bit about what is going on here. So right now we have one state suing 4 other states. Seems a little bit weird, right? Not really. This happens all the time. In fact, it's even detailed in Article 3, Section 2. Let's take a look. This is, yes, I got the right slide. This is from the website called constitutioncenter.org, and it's showing us Section 2 here. The judicial power, in Section 1, they define the Supreme Court. They establish the Supreme Court in Section 1. But Section 2 says that the Supreme Court can hear these types of cases. The judicial power shall extend to all of these things, including to controversies between 2 or more states. So when one state has a problem with another state, Supreme Court gets involved. They have original jurisdiction over that. So you can just go right up to the Supreme Court. You don't have to go through the lower level courts. If you remember with Mike Kelly's case, he filed in the Commonwealth and it went up to the state Supreme Court. Then it went up to the Supreme Court. And it can go through that way. It can go through a federal district court to a federal circuit court, then to the Supreme Court. This one, right on the Supreme Court door. 2 states are fighting with one another. Boom, we need you guys to resolve this thing. And so let's take a look at this lawsuit. Now, once again, 4 different states. So the way I want to approach this one is sort of flesh out what the main arguments are. Then we're going to dive down a little bit and go into each individual state. And we're going to do one to 2 slides on all of the other states. Then we're going to jump into the live chat. So let's get into it. This is from the opening filing, the opening pages of the filing. It says here, as set forth in the accompanying brief and the complaint, the 2020 election suffered from significant and unconstitutional irregularities in the defendant states. And so this is the summary that we're sort of going to detail in a little bit further, but I want you to pay attention to sort of the pattern that we're talking about. We're seeing this same pattern across all 4 of these other states. Non-legislative actors. So non-legislative actors are going to be people who are not a part of the legislature. That's going to be the Secretary of State, the Board of Electors, anybody who's implementing policy. Those individuals their purported amendments to the state's duly enacted election laws are violating the Electors Clause and the plenary power of the state legislators. So plenary power is talking about just they have it all. They have total power to govern their elections. They're also saying that some of the irregularities are from intrastate differences in the treatment of voters. So this is going to be an equal protection type of a claim where they're saying that one bucket of votes is different than than another bucket of votes. One bucket that has more signatures or has an authentic signature is being treated differently than one that doesn't. One is more credible of a vote. The other is not so credible, but they're being treated the same. Or some votes are being dumped. Some are being counted. Some are being counted that should not be counted, which is sort of, watering down the validity of everybody's votes. If I get 1 vote and you get 1 vote, both of our votes count for 1. But if I get 1 vote and you get 2 votes, my vote really counts for half of the same value because your second vote is going to be sort of encroaching and watering down the impact of my vote. So that's what they're talking about here, that the law through the 14th Amendment, as it's applied down to the states, ensures equal protection across the board. And we're not seeing that. We go back to the filing. It says that some votes are more favorable to others, whether they're lawful or unlawful in areas administered by the Democrats, and the appearance of voting irregularities in the defendant states would be consistent with unconstitutional relaxation of the ballot integrity protection. So we're going to get into a lot of that here in a quick minute. All right, so let's start with Pennsylvania. All right, so there's 4 states. Pennsylvania is the one we want to start with. There's going to be a lot of text on this slide, but I am going to go through it, so don't gloss over just yet. All right, we have the Commonwealth of Pennsylvania, and what this does is in about 5 to 6 different paragraphs, it breaks down how sort of the format is the same across the board. So we're going to follow the same pattern as we go through all the states. Pennsylvania, they got 20 electoral votes, and the margin here, Biden is winning by 81,000. So Trump got 3.4 million. Trump got 3.36 million. Biden got 3.4 million, the difference being 81,000 votes. And there are constitutional violations here which would alter that margin. So if these are remedied, then those 81,000 votes would flip the other way. Specifically, they're talking here about, once again, Kathy Boockvar. They're saying without legislative approval, she abrogated unilaterally on her own several Pennsylvania statutes that require signature verification for absentee and mail-in ballots. So Kathy Boockvar, the Secretary of State, on her own, changed some rules that are written elsewhere in the Pennsylvania statutes, and the Pennsylvania legislature did not ratify these changes. She just did it on her own. She just said, we're going to make these changes because I want to, and I'm the Secretary of State, and I'm allowed. On August 7th, the League of Women Voters of Pennsylvania, then they filed a complaint against Secretary Boockvar, and they were looking for what's called a declaratory judgment, saying that the existing signature verification procedure for the mail-in votes were unlawful for a number of reasons. So that was actually filed on August 7th. So the response in the Kelly case was saying they should have filed a lawsuit before. Somebody did. Somebody did file a lawsuit before. It's in the League of Women Voters versus Boockvar. And it looks like on September 11th, the Pennsylvania Department of State, which is run by the Secretary of State, Kathy Boockvar, they issued a revised guidance. So once again, August 7th, they enter into a settlement. September 11th, Boockvar comes back out, issues new guidance that authorizes the county Board of Elections to set aside, it says that it does not authorize them to set aside returned absentee or mail-in ballots based solely on signature analysis. So Ms. Boockvar, through her office, the Department of State, they go in, they rewrite the election code, and they're saying, listen, we do not authorize you to get rid of ballots based solely on signature analysis, which is not what the underlying Constitution says. This guidance is contrary to the Pennsylvania law. The election code mandates that all applications for an absentee or mail-in ballot shall be signed by the applicant. That is 25 Pennsylvania statute sections 3146.2d, 3150.12c. And number 2, the Pennsylvania voter signature verification requirements are expressly set forth, once again, in the statutes, Pennsylvania statute 350A3, 1 through 2, and so on. So it's written in the rules. But Boockvar just came out, modified it through her Department of State. They issued revised guidance, and they changed those rules. Remember, the legislature already put those rules into the law, but Ms. Boockvar came out and changed them. The Pennsylvania Department of State guidance unconstitutionally did away with the statutory signature verification requirements. Approximately 70% of the requests for absentee ballots were from Democrats, and 25% were from Republicans. Thus, this unconstitutional abrogation of state election law greatly inured to former Vice President Biden's benefit. Right? And that's what we're going to see here. So in Pennsylvania, we spent probably the most time on Pennsylvania. There are still other cases out of Pennsylvania that are moving forward, but this is the same pattern that we're going to see in these other states. We're going to go to Georgia, we're going to go to Michigan, we're going to go to Wisconsin. The general concept here is that somebody in the state government who is not a part of the legislature changed the election rules at the last minute. They didn't have any constitutional authority to do that. None of these actions were confirmed by the state legislature. They weren't authorized. They weren't voted on by the people. They weren't approved. This was all just done by the executives. They changed the rules. That's not allowed, is what this argument is saying. And they're saying that It's a pattern that we're seeing across a number of different states. Let's go on over to Georgia. Once again, same sort of introduction. We're seeing here Georgia has 16 electoral votes, and the vote tally was 2.45 million for Trump, 2.47 million for Vice President Biden. Again, tiny margin, 12,670 votes. They're saying that Georgia's Secretary of State, Brad Raffensperger, without legislative approval, unilaterally, once again, abrogated Georgia's statute governing the signature verification process for the absentee ballot. So again, the signatures, they're not checking signatures. OCGA Section 21-2-386A2, this is a statute in the state of Georgia, which is on the books. This is a law. It says it prohibits the opening of absentee ballots until after the polls open on Election Day. In April 2020, however, the State Election Board adopted Secretary of State Rule 183-1-4-0.9-0.15. Good Lord, that is a heck of a statute. It says that processing ballots prior to Election Day that allows them to begin opening them up before Election Day, which, like, again, you think about that and you say, oh, who cares if they open them sooner than later? I get it, right? I'm sure there's a good reason why they don't want them to open them sooner rather than later. I think there's probably a lot more propensity for fraud in those types of situations. But for the average person, you may just be sitting there going, so what if they open them early? We're sick of waiting around for them to count the ballots. We're sick of them, taking 4 days to give us the results. Why did Arizona take, a week and a half to get our results in? Maybe if they started counting the votes earlier, we'd have our results sooner. We wouldn't have to wait, a week to get our final election tallies. I get it. I want free, fast, and fair elections as well. And fast also. We don't want to be waiting again. We don't want to go through this again. So what's the problem? The problem here is that Brad Raffensperger didn't have the authority to make that change. The people did. The legislature did. Not Brad Raffensperger. But he made the changes anyways. And we see here as it goes on, it says Georgia law authorizes and requires a single registrar to go through this process to reject an absentee ballot if the voter failed to sign the required oath or they failed to provide the required information. The signature appears to be invalid. There's a number of reasons why this should be dumped. And it says here that the information does not conform to the information on file or the voter is otherwise found ineligible to vote. So OCGA here, another statutory law. It's written into the law. He goes on again. There's a whole paragraph right here talking about curing absentee voting. More statutes to facilitate the cures. Georgia law requires with the relevant election officials to notify the voter in writing. Specifically, it details what it's supposed to do, what the government is supposed to do. It's written on, it's already voted into law by the state legislature, which is elected by the people. This is already in law. This has already been voted on. So when they talk about disenfranchising people, what about the people who voted for those legislatures who voted for these laws and implemented these changes? Now we have on March 6th, 2020, in the Democratic Party of Georgia versus Raffensperger, we've talked about this case a lot, the Secretary of State entered into a compromise settlement agreement on March 6th with the Democratic Party of Georgia. So Republican Brad Raffensperger entered into an agreement with the Democrats. I think it was the Democratic Party of Georgia, the Democratic Senate Committee, the Democratic House Committee, everybody who are all Democrats, they filed a lawsuit and they entered into an agreement. And that settlement materially changed the statutory requirements for reviewing signatures on absentee ballots. That's it. They were supposed to confirm the voter's identity by making it they made it far more difficult to challenge defective signatures. We jump down to paragraph 72. It says Georgia's legislature has not ratified these material changes to statutory law. They didn't agree to any of this settlement agreement. They didn't agree to altered signature verification requirements. So this law or this settlement agreement violated the Constitution. And so that settlement agreement is what they're arguing here is that it should be thrown out. I have a second slide here on Georgia. It says this unconstitutional change materially benefited Joe Biden. Vice President Biden had almost double the number of absentee votes, 65.32% as president versus 34.68% as president. The effect of this unconstitutional law, which made it more likely that ballots without matching signatures would be counted, had a material impact on the outcome of this election. And it goes in here, and this is very interesting. It says specifically there were 1.305659 absentee ballots. So 1.3 million absentee mail-in ballots were submitted in Georgia in 2020. 1.3 million in 2020. There were 4,786 rejected in 2020. Sounds like a small number. It's because it is. It's 0.37% rejection rate. By contrast, in 2016, the rejection rate was 6.42%. So they had they had 13,000 absentee ballots being rejected out of 213 that came in. So that's a difference of 17 times greater. The rejection rate was 17 times smaller in 2020 than it was in 2016. And they just do the math on that. If the rejection rate of the mailed-in absentee ballots remain the same in 2020 as it was in 2016, you can just do the math on it. 83,000 less tabulated ballots. And the statewide split would have been 34% for Trump, 65% for Biden. If you reject at the 2016 rate, then you're going to find that Trump and Biden would decrease Trump's votes by 28,000, would decrease Biden's votes by 54,000. That'd be a net gain for Trump of 25,000. That would be more than needed to overcome the advantage. The difference there is only 12,600. Trump would win by 12,900 votes. So you just do the math. It says regardless of the number of ballots affected, the non-legislative changes were in violation of the Electors Clause. That's Georgia. Once again, Brad Raffensperger, Secretary of State, Secretary of Elections, whatever they call that there in Georgia, made some modifications last minute, happened as of 2020, sometime in March, entered into a settlement agreement with the Democrats. They filed a lawsuit. They went up to him and said, hey, we don't like any of your rules. We want new rules. And he said, well, I can't give you all the rules, but I'll give you some of them. Let's give you some of these changes. Entered into an agreement. Agreement went into effect. Legislature never voted on it. They just implemented it, ran it across the board. We go from a 6.42% rejection rate in 2020 to a 0.37%, less than 1%, just over a third of a percent of a rejection rate in 2020. That's what the Democrats wanted. Why did they want that? Very, very interesting. Why did they file that original lawsuit and enter into a settlement agreement with Brad? What happened there? Very curious. All right, let's change gears. Let's go over to Michigan. Same situation in Michigan. Here we have 16 electoral votes. We have 2.6 million went for President Trump, 2.79 million went for Biden. Margin of 146,000 votes. This is the biggest one of the four. In Wayne County, the margin was 322,000 votes. Michigan, Secretary of State Jocelyn Benson. Once again, we covered this lawsuit prior to the election. We went over this. Jocelyn Benson, we've talked a lot about. Without legislative approval, she unilaterally abrogated Michigan's election statutes related to absentee ballot applications. Weird. And signature verification. Weird. Happening again. We're 3 for 3 now. Michigan's legislature has not ratified these changes. Its election laws do not include a severability clause, which means that those changes need to basically invalidate across the board. They're saying, as amended in 2018, the Michigan Constitution provides all registered voters the right to request and vote by an absentee ballot without giving a reason. So you can see here, this site here is the Michigan Constitution, Article 2, Section 4. So presuming this is an accurate site, which I have no reason to doubt that it isn't, he says all registered voters are given the right to request and vote by absentee ballot. Okay, so they can request and vote. However, on May 19th, Secretary Benson announced her office would send unsolicited absentee voter ballot applications by mail to all 7.7 million registered Michigan voters prior to the primary and general elections. Her office repeatedly encouraged voters to vote absentee because of COVID-19. It did not ensure that the election systems and the procedures were adequate to ensure the accuracy and legality of the historic flood of mail-in votes. So they're going to mail out 7.7 million votes and basically have no way to verify the signatures when they come back. And then they're going to come into court and say, you can't disenfranchise all 7.7 million of those people. That's crazy. We can't verify that they're actual voters because we kind of blew that. However, we're going to count them. It says, in fact, it did the opposite and did away with the protections designed to deter voter fraud. The Michigan legislature declined to include the Secretary of State as a means for distributing absentee ballots. The Michigan legislature never said that this person has the authority to do that. There's no basis for it, that the Secretary of State can just unilaterally on her own just go out there and send out a bunch of ballots. That's not in the rules. Under the statute's plain language, the legislature explicitly gave only local clerks the power to distribute absentee voter ballot applications. Because the legislature already declined, they declined it to explicitly include her, Secretary Benson lacked the authority to distribute even a single absentee voter application, much less millions, that she flooded across Michigan. And it goes on a little bit further. It says she launched a program in June 2020 allowing absentee ballots to be requested online without signature verification as expressly required under Michigan law. The legislature once again did not approve or authorize Secretary Benson's unilateral actions. Constitution says, yeah, you can get one. You can get a right. You can get an absentee ballot. You can vote by mail. You got to come and request it. Secretary Benson, yet again, because of COVID-19, it's ruining everything. She turns around and says, gosh, we better just send all these puppies out to 7.7 million people. Oh, my goodness, Ms. Benson, that is a lot of ballots. What are you going to do to verify the signatures when they come back? Well, how about we just waive that? If they request it online, not a big deal. Well, Ms. Benson, do you have any basis under the Michigan law to go ahead and do this? No, we don't. It says only local clerks can do that under Section 168.7593B, but we're just going to do it anyways because we want to enfranchise people. And we know that if they file a lawsuit about this, we'll just call them racists and we'll just call them anti-democratic, and we'll just say that they're trying to instill a coup, they're trying to undermine the will of the people because they want to take away the vote from people. Even though they broke the rules, they're the ones who modified the rules. What should the penalty be for them? We're going to find out. All right, let's finish up with Wisconsin. Wisconsin is the last one on the list. Same pattern yet again, margin of 20,565 votes. And in two counties, Milwaukee and Dane, Mr. Biden's margin significantly exceeds his statewide lead. So Wisconsin has 10 electoral votes. It was 1.61 million to 1.63 million. The margin is 20,000. In 2016 in Wisconsin, there were 146,000 mail-in ballots out of more than 3 million ballots cast. In stark contrast, in 2020, there were 1.275 million. So, my goodness, 900% increase over 2016. So it went from 146,000 to 1.2 million, which is a massive change. Wisconsin statutes guard against fraud in absentee ballots. And we can quote here, Wisconsin statute section 6.841, in the law, passed into law by the legislature. This gets changed, but here we see that voting by absentee ballot is a privilege exercised wholly outside the traditional safeguards of the polling place. The legislature finds that the privilege of voting by absentee must be carefully regulated to prevent the potential for fraud or abuse. In the law, written, passed by the legislature. In direct contravention to this law, the Wisconsin Elections Commission, the WEC, and other local officials unconstitutionally modified the election laws, and they did it in a way that weakened or did away with the security procedures that the legislature already put in place. Largely, they're talking about the unmanned drop boxes. The mayor of 5 Wisconsin different cities, it looks like Green Bay, Kenosha, Madison, Milwaukee, and Racine. They were all Democrat majorities. They joined together. They developed a plan called the Safe Voting Plan for Wisconsin 2020, where they were going to use secure drop boxes to facilitate the return of the absentee ballots. It's alleged in an action recently filed that there were over 500 unmanned, illegal absentee ballot drop boxes that were used in the presidential election, which is not allowed. So you can see here, I went from paragraph 109 down to 126, where I'm finalizing this and saying Wisconsin legislature did not ratify these changes. Election laws do not have a severability clause. So in between those different paragraphs were a lot of different laws, a lot of analysis, a lot of the different things that Wisconsin was doing. And one of those things was that individual by the name of Scott Donnell, I think his name was, something like that, where he was in Wisconsin and he's literally posted on Facebook that all you need to do if you want to request an absentee ballot is just go onto this website, fill out a form. We're going to send you a absentee ballot. You don't even need to upload your identification. So in his Facebook post, he just put, it says box number 7, upload your ID. Skip that. We're waiving that. Why? Coronavirus. Everybody's dying. Therefore, we don't need to verify your signature for some reason. They just made those changes. And the legislature never approved that. The people never voted on that. This was just a couple of people in positions of power who were responsible for running the elections, changing the rules across the board in Wisconsin, Michigan, Georgia, and Pennsylvania. And this one is knocking on the doors of the Supreme Court as well. So we're going to see where that one goes, which is a good reminder to have you go ahead and hit that subscribe button. Give us a thumbs up on the video if you're enjoying the content. Helps us out immensely, and we very much appreciate it. And so that's what I've got for the show today. Let's take a look at some of the super chats that have been coming in. We're going to change it up a little bit. I'm not going to turn on the scrolling chat bar because I'm not sure how much that does, but we do have the slide. So Wolfgang Deo is in the house, and here is his super chat. He says, when does private business governance intersect with public constitution governance? Why are we slaves to Walmart that can cancel us for belief? It's a good question, Wolfgang, and I'm not real sure where you're going with that, but when does private business and governance intersect with public constitution and governance? So I think every day of the week, every time that you're acting in any capacity, you're acting under the laws of the government. So as a business owner, you got to comply with the rules. You can't do illegal things. You got to follow the regulations, got to pay your taxes, all of that good stuff. And so I'm not sure what the Walmart comment is about, but I don't shop there, so I don't have much to say about that. We have another super chat came in from Brian Hack. Says, happy belated birthday, Ma. Hi, Rob. Hi, Faith. Hi, R&R. Hi, chat, and some sweet Java, since outside is lava as well as inside. So good to see you, Brian Hack. Appreciate you being on the program, and it's good to see you, and hi right back at you. I hope Ma had a good birthday. We have Sharon Quidney, who says, could you please explain how it is that Texas has standing in their lawsuit today? So they're a state, and they have the ability to file claims. I think what their argument is going to be is essentially equal protection, that their votes. So let's think about this as if every single state was a person, kind of. If Texas was a person and these other people were, these other states were persons or people, and though they got more votes than Texas did, or maybe that's not a good analogy, but here's the argument. Texas is saying our votes don't count as much as these other states. These other states have less credible, less, I would say, security in their elections. We can't be confident about the integrity there. And we know in Texas that we're very secure, that all of our votes count. We know who our people are. We know that the votes were counted. They were registered voters. We verified the signatures. All of the identification was done properly. It was a legitimate election. These other states, not so much. We can't be sure about their election. And so Texas, as a state, is going to be impacted by the result of the election. They're going to be impacted by Joe Biden and Kamala Harris if they secure the White House. So they have a potential to be harmed by the next administration. They're one of the 50 states. They've got a lot of reason to be invested in this. And they're saying that the other votes were unlawful and illegitimate, and they're harmed as a result of that. I think that's what their ultimate argument is going to be. All right, we have Shaheen K, who says, can the striking similarity of conduct in disputed states be seen as evidence of a plot without direct proof? Details varied, but stopping the count, ejecting watchers, etc., all strikingly similar. So, yeah, I think that's kind of what this lawsuit is doing in particular, right? We just saw sort of the same format in all those different 4 states. One, this is the number of votes. This is the difference. This is the margin. Here's the bucket of votes that we're contesting. Here's the law that the legislature put in place, and here's how the executive individuals manipulated the underlying rules. Now, what you're talking about is sort of, are you able to bring criminal charges? Can you connect this into a conspiracy? Can you identify these individuals and say that they were colluding with one another? You'd really have to go and find some evidence about that. You'd have to go and, get a document that George Soros or whomever, Mark Zuckerberg or any one of these people who are, funneling money to all of these different board of electors or secretary of states or donating to their campaigns or something like that would connect the dots between all of them. But other than that, I think you're going to have to analyze each claim individually. You're going to actually have to go through, as we just saw in this other lawsuit, and say, this is what happened in Michigan. This is what happened in Pennsylvania. This is what happened in Georgia, and so on. And the court is going to need to take every one of those in turn and address them. Now, because the state of Texas is bringing them all together, I think this is a compelling format. You can see the pattern there when they delineate it so clearly like that. Good question. Thanks, Shaheen K. Good to see you back here. He said, Demetrius Parham says, what if they rejected it to focus on Texas? Yeah, it's a good question. There's a lot of backroom dealing that can go on in these cases. And the Supreme Court could be looking at it and just saying, yeah, look, We've got now multiple different lawsuits. We've got this one and this one and this one over here. They're all coming in, and these are not so good. But this one's good. We're gonna really rule on this one and address them across the board. Because think about that. If they rejected Mike Kelly's argument, that lawsuit, in this lawsuit, Pennsylvania's included. It's part of the four. It's one of the big ones. So it's already being addressed. So just because he lost that claim doesn't necessarily mean that all of the other claims are going to fall at the Supreme Court level. Now, that being said, it's not a good sign, right? If you're knocking on the door of the Supreme Court and they tell you to go away, not particularly a win, but we'll see. There's still some time left. And as we have talked about in Rudy Giuliani and from Jenna Ellis and from a lot of their lawsuits, they're saying that they're not even caring about this December 8th date. They don't even care about the December 14th date, which is when the states send the votes over to the House of Representatives. All they're really focused on, and we've seen this in their litigation, we've seen this in court documents, they're concerned about January 6th. That's their date. So they're going to keep moving forward on this stuff. We're going to see what happens. We have KCT, who says, I'm super excited about Ted Cruz arguing this case if it comes down to it. Thanks. There it is. Thanks for the show. Hiya, Faith. So that comes from KCT. I think a lot of people are excited about Ted Cruz arguing the case. We have a couple that came over from D. Marlowe. D. Marlowe with 2 super chats. He says, the latches exception, fleeting, escaping review doctrine, please comment. So if the escaping review fleeting exception to latches is no longer law, that's a crock. So I'm not familiar with that specific quote, the fleeting or the escaping review doctrine. That's not ringing a bell for me there, D. Marlowe. But the latches by itself is not a ridiculous concept. I mean, it makes sense. You don't want somebody who can prevent their house from burning down, who can say, hey, that wire's loose. If I address that now, I'll save my house from burning down. You don't want them to look at that negligence and just ignore it. And then when their house does burn down, they go bring a lawsuit, right? That's not good. You don't want to do that. You want to encourage people to find remedies before the harm happens. And so the same argument is happening here. They're saying, well, you should have brought these claims prior to the election. And I think, when we were talking about this last night in the Discord, I think that's more pertinent for maybe Sidney Powell's lawsuits. If she knew that this Dominion stuff was a problem for so long, then she could have, filed claims and sought discovery and sued them for fraud and all different sorts of claims. She didn't have to wait until after the election. But she kind of did, because the harm came after the election. If she filed a lawsuit before the election, they would have said, what are you talking about? It's secure. We haven't seen any problems. There's been no harm. So they would have said, you have no standing. So they would have dismissed it that way. So, look, a lawyer, a judge can find any reason to do basically anything. Okay. The law is massive. There are, principles and theories and case law, and you can find whatever you want. You can make an argument for basically anything. Some of them are good. Some of them are not so good. I think the latches argument for some of the Sidney Powell lawsuits is more reasonable than it is for the Mike Kelly lawsuit and for some of the Pennsylvania cases. Because once again, there are so many changes that happened at the very last minute. I just showed you on the program here that on October 28th, we got a final decision from the U.S. Supreme Court about Act 77 and about the new deadlines that were imposed by the Pennsylvania Supreme Court. So, literally days before the election, this stuff is still in flux. So the only real recourse is to file a lawsuit after the election. This latches argument, I think, is a stretch. We have another one from Sarah Ann, who says, Lord bless you with all good success. Keep on fighting the good fight, from Sarah Ann. Thank you, Sarah. I appreciate that. Such a nice thing to say, and I appreciate the encouragement. So we will keep on fighting the good fight. We're going to keep being here, and I appreciate you joining on the program. We have Wolfgang Deo, who says, did the people vote in 1918 during smallpox? I would imagine so. I would guess that, we've had a lot of, problems in this country for a long time. And that doesn't mean that we just change the rules to meet the crisis, right? The rules are eternal. The rules are the system of government. The way that we conduct ourselves is foundational. It's eternal. We can modify it. We can make amendments. We can make changes around the edges, but we got to go through the formal process. You can't just say, okay, it's COVID time, so now we can all just vote by mail. Well, who said so? Well, I did. Well, I have the power to do that. So we're going to vote online. We're going to vote on your app. Start an app. We're just going to make these changes. You got to go through the formal process. That's why we have it. It's called checks and balances, folks. Remember this from your social studies class in 4th grade. checks and balances. If you have one branch of government that just starts encroaching on another branch of government, this is how you get a despotism. This is how you get a tyrannical government. One just encroaches all over, steps all over the other one, and they start seizing their responsibilities and bringing them into their purview. We do not want that. We do not want the executives going in and just taking over what the legislature does. Doesn't work out too well. Otherwise, why do we even have a legislature? What's the point of that? Why don't we just give all the power to an executive and just say, hey, you're the monarch of the country. Do whatever you want. Run things however you want. Does anybody want to live in that system? I sure don't. All right. We have Durago Sullivan. He says, the Supreme shut down this Pennsylvania suit. Now we know they clearly intend to rubber stamp a Trump loss on behalf of the establishment. So that comes from Durag O'Sullivan. Yeah, it's looking closer to that. We're not quite there yet. I will tell you this, honestly, I have not seen much more from the Pennsylvania Supreme Court denial than what I just showed you at the beginning of the program. I was prepping the show and I wasn't even checking Twitter. And then I checked Twitter literally before I sat down in this chair and I saw that change. And I was like, oh, dang it. I just prepped to talk about that case. So we made some last minute changes, but we'll see. Like I said, Texas versus the other 4 states, that's still in front of the Supreme Court. There are a couple other cases that are in front of the Supreme Court. So we'll see what happens. Now, once again, not a good indicator if they're going to be willing to, there could have been something, they could have done something else with this case. They could have, granted some additional time. They could have consolidated it with another case. They just didn't. They just rejected it outright. So that certainly has, some consequences. And largely, I think it's a problem because there were some good arguments in that Mike Kelly case. As Ted Cruz, who has been in front of the Supreme Court 9 times, he said, hey, it's so good, I'm willing to go in and argue that puppy. Doesn't get that chance anymore. Anna Medina chimes in with a nice super chat. We have a superhero flying through the sky. Thanks, Anna. Appreciate that. We have another one from Sharon Quidney, who says, is it possible that SCOTUS refused to hear Kelly because the issues would be dealt with in other cases coming up? Yeah, I think so, Sharon. I think that is very pertinent. And I answered that a very similar question just a couple of minutes ago. But yeah, the idea is here that Texas versus the other 4 states, they are addressing the same issues. The Texas versus Pennsylvania would necessarily include the Pennsylvania issues. And if the Supreme Court comes down and says, yeah, we're going to draw a hard line in the sand, anything that is this sort of stealing of power by the executive from the legislature, we're just going to come down. All that type of stuff is unconstitutional. Pass those back out to the states. The individual states could then institute the various remedies in their localities. They could, theoretically, they could probably call for a new election. There's no time to do that. They wouldn't do that. They'd probably just, there'd be enough of an uproar in those different localities that the people would demand their legislature does something about it. They could go and appoint the votes where they want to appoint them. So we'll see. Not so sure yet, but there are still cases bubbling up to the Supreme Court. All right. The next one we have is from Wolfgang Deo. Again, he says, perhaps these are individual actors. However, what do all these actors have in common? The Democratic Party. Does the party have the capacity? So another one from Wolfgang Deo. I don't know if you are asking, are they individual actors? What do they all have in common? The Democratic Party. Does the party have the capacity? Yeah. Okay. So I see what you're saying. So it's a good observation that, they're all, that's not true, right? Because Brad Raffensperger is a Republican out of Georgia. So we don't want to forget that, but he did enter into a weird settlement agreement with the Democrats. And the Republicans, I think, were involved in that to a certain extent, but I'm not sure how much. The Democrats filed the original lawsuit, and then he settled it. You would think if you were a hardcore Republican, you'd say, no, we're not settling anything. File that sucker in court. Bring the lawsuit. We are going to stand by our rules. We're just a few months out from the election. We're not settling anything. Take it into court. And they could have done the same thing that they basically did in Pennsylvania. They could have taken this up to the Supreme Court. Supreme Court could have knocked this thing back down and said, no, the original rules are going to stand. There were election lawsuits that were brought in Arizona, but we didn't change much here. Brad Raffensperger just kind of on his own, entered into an agreement. They settled that case out. We have Bruce Wilk, who says, seems to me it's not what you know, it's what you can prove. Yeah, I think that's pretty accurate there, Bruce. It is one of those, a lot of people have a lot of inclination, a lot of feelings kind of in your gut that this election just doesn't feel that right, but that doesn't get you anywhere in court. You got to bring some evidence in. You got to bring some facts in. You can go on the media and say there's cracking all over the place, but unless you file it in your documents and present some evidence, It's not going to go anywhere, as we are seeing. We have Helen Alera with a super chat, says, #1 fan. Thanks, Helen. Appreciate that. Thank you so much for being a part of the program. Very generous, very nice. We have UFO Man, Trump one's hand down. Great stream, R&R. Thanks, UFO Man. Appreciate you being a part of the program. We have another question coming in here from Cablebox. Says, I heard Louisiana, Arkansas, Alabama, Florida, Kentucky, Mississippi, South Carolina, and South Dakota just joined Texas's lawsuit. Can you confirm? So, yeah, I will confirm that for us all here tomorrow, Cablebox. So I think that what we're going to see is sort of what I talked about in the Brnovich case, which we just covered on this show. You're going to have a lot of states moving as intervenors and, or actually, yeah, as additional petitioners. And so they can join the lawsuit. And I think that's probably what you're going to see. I think there's going to be a lot joining here. So this is one of those situations where now the Supreme Court goes, wait a minute, we got like 35 states here. They're all on this case. We got to do something about this. So that's why that may be the reason why they dismissed Mike Kelly's case in favor of wanting to address a bigger case. Mike Kelly was just talking about Pennsylvania. Maybe they want to craft a resolution that all of the other states are going to be involved in. That would make sense. I mean, I think that makes logical sense. So we will see what happens. Good question, Cablebox. Appreciate that. We have another one over here from Hidden Prophet who says, hey guys, love the show. Keep up the great work. Also, to me, this feels like I'm living in Plato's The Allegory of the Cave. Yeah, with the shadows on the wall. Plato's allegory of the cave, where you're kind of watching, you can't see reality that's behind you. Do you remember the allegory of the cave? There's a person sitting in a chair, and there's a figure. There are figures moving on the walls in front of them. So this person is bound. They can only look forward. They can only see directly in front of them, and they see these figures moving on the walls. They don't know what it is. Now, you and I would know they're shadows, but they don't know what it is because they've never seen a person. They've never seen an animal. They've never seen a creature. They're just watching these weird shapes moving around on the walls before them. But what they don't realize is that behind them, there's a whole world going on. There's people outside of the cave moving around the entrance of the cave, and they are causing the shadows. And so when you're sitting in the chair in this allegory, you are sort of blind to the real realities of the world. You're just sitting there observing. What you see is what you think is reality, but that's not so much the case. When you get up, when you're unshackled from your chains and you leave the cave, you realize that the shadows on the wall were just shadows on the wall. Reality is really outside. So sort of like waking up a little bit and coming to recognition about what is real, what isn't, what is the nature of reality. A lot of people are sort of feeling that right now, that we're seeing a lot of activity, but it doesn't feel like it's really connected. A Biden victory or a Biden presidency is a shadow on the wall, but what is really outside the cave? It's a good question. Interesting allegory there, Hidden Prophet, and I appreciate that. All right, let's go over to John. Jenna Ellis says that injunctive relief is denied in Pennsylvania. Not the case. Near the top of her Twitter, if you want to see, can you please clarify if she is right? Yeah, let me see if Miss Faith can pull that up. We'll get back to you on that one, John. Let's see if we can find that. We have Rolly Murray who says, come on, man. We need to start counting the votes early just so you know how many bins we need to put under the table. That one's from Rolly Murray. And, yeah, I mean, that's the other component to this, right? If you know what the deficit is, if you can start counting these things, then you can go, wait a minute, we were expecting 60% of these to go to Biden. It's looking like 60% of these are going to Trump. Yikes. All right. That means I'm going to make a phone call. I got to notify the local DNC. Hey, we are totally screwed right now. I need you to go out there and go collect those ballots. Go rally your people to vote. Go incorporate some other techniques in order to shift this tide coming. And there's a lot of opportunity for malfeasance. You want to know what the deficit is so you can close the deficit. If you can identify that early, then that's in your favor. And when we were talking about all of these election cases before the election occurred, all the litigation, we were all sort of raising those concerns. That's weird. Why does Pennsylvania want to change it from November 3rd to November 6th? Why is that? Why are those additional 3 days important? Well, their argument was, because people may not know any better. People may be so dumb that they can't get their ballots in on time. They may mail them out on election day, not 3 days before the election. Even though, in Arizona we had, hey, mail this 7 days, mail this, mail everywhere. It's pretty obvious you got to mail your ballot back on time. You got to account for the transit time from your house to the postal service and to the election board. Pennsylvania didn't want to do that, so they changed that. North Carolina, they moved theirs 12 days. So all of these different states were asking for extensions. And the big question was, well, why? Why don't you just tell the people to get their ballots in early? You got a lot of time to do that. Why don't you do that? The speculation back then was they needed those 3 days to figure out what to do with the votes. I mean, it was pure speculation back then. You can go back on the prior shows. We were talking about that. In Pennsylvania, on election night, Trump was winning. They had 3 additional days to go find some more votes. And by God, they found them. Okay, whether that was malfeasance or whether they were just coming in late because the deadline was moved, we don't know. But that's the problem with changing the rules at the last minute. That's the problem with the Supreme Court coming in and just saying on their own, we're going to move the deadline back 3 days. It muddies the water. And so now they're turning around and saying anybody who's questioning the formal process is a conspiracy theorist or is, not being useful to democracy. Meanwhile, the only thing that we're trying to discuss is, were the rules followed? And if not, why not? And is that a problem? Does the Constitution, does the law mean anything? Or is it just a guideline? Is it a document that has weight? Or is this just like a take it or leave it proposition? Because I know which one I want to be the case. I know what country I want to live in. Some people maybe don't feel the same way. All right, we have Eagle Eye Gardens who says, do judges rule against the statutes? If so, what happens after those types of rulings? How did Facebook become an official platform? Unprofessional. So I'm not sure what the second part of that question is there, Eagle Eye Gardens. Also, how did Facebook become an official platform? Is FB Facebook? I don't know. Do judges rule against statutes? So yeah, what judges are doing is, at least in the context of the Supreme Court, what they do is they tell you what the law is, right? This is what's called judicial review. We learned this in Marbury versus Madison. This is sort of the seminal case on how the Supreme Court works, but it's called judicial review. They get to say what the law is. So if in this case of Texas versus Pennsylvania, Georgia, Michigan, and Wisconsin, if those different statutes or these different issues come up in front of the court in the Supreme Court, they can turn around and say, listen, that is unconstitutional. You presented us with this law in this statutory scheme. That's unconstitutional. Therefore, you can craft the remedy state about what you want to happen next. But we're telling you, under the federal Constitution, under the Electors Clause, under the Elections Clause, these are the rules. You didn't follow the rules. Therefore, your rule changes are unconstitutional. Now you go fix it. You broke it, you fix it. So they could do that. So they could basically declare that those modifications, those changes were unconstitutional and then send it back to the states for them to do what they want. All right, we have Bobby Boucher in the house. Bobby Boucher says, thank you for translating for those of us who don't speak law. You are a true freedom fighter. Thanks, Bobby Boucher. Bobby Boucher, that was the Adam Sandler movie, right? That was Waterboy, I think. Bobby Boucher. Good movie. I watched a lot of Adam Sandler growing up. A lot. All right. We have another one that comes in from Robert Hanrahan, who says, SCOTUS has consolidated cases before, as I recall. Yeah, they have. And actually, we just talked about one today. So they consolidated 2 cases out of Arizona, the Arizona Republican Party versus the Democratic Party. And they also consolidated Brnovich, which is our Attorney General, versus the DNC, I think is what that one was. So they just said, okay, these issues are very similar. We're going to consolidate them. They literally did that on their own back in, I want to say that was October. So they could be doing that here. They could be saying, all right, well, this new Texas lawsuit is looking like it's all encompassed in this one issue. All of the issues are in here, and we're just going to rule on this. We're just going to say there's a hard line between what the executive can do and what the legislature can do. The executive, you stepped over the line. You got to get back on your side of the aisle. Good question, Robert. Thanks for being on the program. We have another one here from Dream Life Myrtle Beach with a CRC. It's a 5,000 CRCs. I don't even know what that is, Dream Life Myrtle Beach. Sounds like a big number, though, and I appreciate that. So thank you so much for that. You don't have a question, but I'm going to have to look up what a CRC is. Sounds like it's an interesting currency, and I appreciate your support. Thanks for being here. Another one coming in from Mike Devlin says, Texas doing the heavy lifting. Why are no other GOP state AGs not joining in on the lawsuit? Indication of Texit secession? As a proud Texan, I hope so. Well, I'll tell you this, Michael. I sure hope that Texas doesn't leave the union. I haven't spent a lot of time in Texas, but if things keep going this way, Arizona just passed some new taxes and Arizona just went blue. And so I'm like, all these California people are coming over here. We're going to be in for it. I think you might see even more people heading over to Texas. And if you get a lot more of the, the same Californians that we're getting, you may need some good red citizenry to come join you over there. So I hope you don't leave. But you're right. I do think that Texas is doing a lot of the heavy lifting here. This is a very interesting lawsuit. I think there's some good issues here. I hope that we get an answer on it. I hope that the Supreme Court just does something with it. Even if it's an answer that we don't like, I would just like for them to give us some clarity, because right now it looks like if they don't, it's going to be status quo for the rest of the year. It's going to be a Joe Biden presidency. We're going to be back here again at 4 years, too, probably, with more election fraud claims. Half the country is going to consider Joe Biden to be an illegitimate president. The country is going to suffer as a result. It's not going to be good. We need some clarity from the third branch of government. We have two branches that are sort of at war with one another. We have the executives taking some powers away from the legislature. We need the judicial branch to come in and say, hey, government, this is how it works. Get in line. I'm hoping that they give us some clarity on this, more so than what we just got today, which was just basically a 2-sentence rejection, which is unfortunate. Another one coming in from Ryan McCusker says, I'm hearing that the Supreme Court didn't decline to hear the PA case. They denied the request for a court order overturning the PA election before hearing the case. Is this true? So it's really hard to say, because currently we just have sort of one line. Right. And what the underlying motion, what the underlying appeal, the petition to the Supreme Court was doing, it was asking two things basically together. Let's see if we can pull this back up here. The order from the Supreme Court today was the application for injunctive relief presented to Justice Alito and by him referred to the court is denied. Okay, so it's just covering that portion of it. But when you go back into the document itself, you'll see that they were asking for a number of different things. They were talking about wanting the injunction in order to buy them time to go and file a petition. I actually think the petition for the writ of certiorari was included in the same document. So they were kind of combining two things. They were combining the injunction. They wanted that emergency injunction to basically stop the certification process. And in the same filing, they also wanted the court to grant the petition for a writ of certiorari. So basically to hear the case. So from what I'm reading there, it's not that the court has declined the entirety of the case, but they've just, as we just saw, they're just declining the injunction. Now, because there's not any more information, I don't know exactly what that means. I'm going to look at the Supreme Court docket here as soon as the show's over, and I'll be fully up to speed on it tomorrow. But I just don't know yet. Right now from that order, it just says the injunction. So maybe they're just referring to dumping the injunction part of the petition. But maybe they are still open to hearing the underlying case. In other words, they're not going to act with an emergency. They're not going to immediately take action on it, but they may still think that the underlying claims have some merit. We will see where that goes. It is a good question, though. All right, we have another one that comes from DBK. Says, thanks for being you. Thank you, DB. That's a very nice super chat. Appreciate you being here, and I do love the beautiful figure on that pair. We have another one coming from JM. Says, how can unconstitutional and illegal elections be okay, and all the ineligible voters that were accepted, tens of thousands? What is this? A third world nation? Yeah, I mean, it is unconstitutional what we're seeing. A lot of these different last minute changes that were done by the executive branch in violation of the legislative purview, I think is pretty blatantly unconstitutional. It was allowed. Votes happened. Votes came in. Is the Supreme Court going to do anything about it? We are going to find out. All right, we've got another one coming in from Wolfgang Deo. Says, there was a group of deplorables in 1776, and they didn't like the idea of the most majestic and magnificent monarch ever to grace the earth. Oh, George, Wolfgang. Wolfgang is clever at times. All right, we have Ron B. who says, hey, Rob, I live in Georgia. There was another video circulating about the Fulton Co. lady in purple counting ballots at a desk cubicle. She lawyered up. She was on Instagram Live. Your thoughts? Happy birthday, Ma. Hey, Faith. What up, Wolfgang? A lot of people making good connections in the house. Thanks, Ron B. So I did not see that second video. I have seen some of the headlines surrounding this woman. And, my question here is, where are the other 4 people? Weren't there 5 people in that room? Where are all these people? Why have they not been found yet? Have I missed that? I didn't see anything today. I didn't see anything yesterday. You would imagine that those other people would be on the record. Somebody would want to hear from them. Somebody would do an interview with them. They may be holed up in their, apartments or their homes or whatever it is. That's fine. Maybe it's important that we know what they're doing. There's a lot. Look, I understand this. As an election worker, you don't want to be the line. You don't want to be in the center of attention. You don't want to be in the spotlight. You don't want any of this, focus of the nation coming down upon you. I do not envy those people. I have a lot of empathy for them, provided that they didn't steal the election from the country, provided that they were doing things by the book. But they've got to clear their names, or if you're performing a public duty like that, and the spotlight comes down upon you, you don't get to just crawl away into your home and just say, I'm not going to answer any questions about that, right? A lot of the country has a lot of questions about this stuff. It'd be very nice if they would just come out and address it. That way we could put this whole thing to bed. The fact that we have not heard from them, and then I haven't seen many people inquiring or really diving deep down into this stuff. I saw a news agency put out some, debunking video. Then you turn around and you read Molly Hemingway's piece. Follow her on Twitter. I think she wrote that over at the Federalist. I could have that wrong, but there's a lot of questions around this, and we want to know what the answers are. But it doesn't look like anybody even cares, or like they're looking. We have Diana White, who says, if Pence didn't want to intervene in the election, why would the Texas suit be different? They are not disenfranchising Dems, but what about us? All right, so I'm not real sure who we're talking about intervening in the election. I think you're talking about Mike Pence, Diana. Is that right? If Pence didn't want to intervene in the election, why would the Texas suit be different? They are not disenfranchising Dems, but what about us? So, yeah, the second part of that I can definitely understand. The main argument here is that they're disenfranchising the people who've already voted. The legislature already passed the laws. The laws were already in place. And if the laws didn't include allowing absentee voting or waiving a bunch of signature requirements, there's probably good reason for that. They probably have talked about those issues, even if they didn't talk about it. If it's not the law, it's not the law. That's the end of the story right there. They were acting outside of the law. It shouldn't count. Those votes that they added illegally, if they're unconstitutional, if the Supreme Court finds that, then they shouldn't count. And the fault is with the government. The government made those changes. They violated the Constitution. They don't get the benefit of their unlawfulness. It's called fruit of the poisonous tree. We've talked about this here. If the government breaks into your house illegally, without a search warrant, no exigent circumstances, and they find something that you shouldn't have, they don't get to prosecute you for a crime. If they find some illegal drugs, they don't get to charge you with the drug crime because they broke the law. They don't get to go in there and they get the benefit of their lawlessness. They don't get to, violate your constitutional rights and then say, okay, well, now we're going to prosecute you for that crime. No. The remedy there is they don't get to prosecute you. The fruit of the poisonous tree is that evidence. That evidence doesn't come into court. It's the same thing here. We'll see if they take any of that into account. All right, another one from James. James says, goal. Thanks, James, for the super chat. See you there regularly. Very nice looking. Looks like a German Shepherd over there. Very handsome young man on your photo. Appreciate you being here. We have Mitch Croy chiming in, says, if SCOTUS decides not to take the case, what then? So if SCOTUS rejects Texas, if they reject all of these other election lawsuits, it's the end of the road, right? The deadlines will come and go. The electoral votes will be cast on January 6th in the House of Representatives. They will probably go in favor of Joe Biden. He gets inaugurated on January 20th. End of the story. All right. We have Brian Hack chiming back in on the allegory of the cafe like Flatland with spheres. All right. I'm going to have to dive into that one, Brian. I appreciate that. We have looks like a Flick Story Entertainment says Louisiana and Alabama join the lawsuit. The AG of each state's confirmed. Yeah, so probably a lot of activity going on today that I just haven't been up to speed on. And I'm going to imagine we're going to log on tomorrow onto the Supreme Court docket, and we're probably going to see docket entries that go like this. Everybody's going to be joining in on that Texas lawsuit. And so we'll have an update on that when we get there tomorrow. So we hope that you join us. We have another message from Aaron on Discord. Says, regarding the Mike Kelly case, the defendants claim judges shouldn't decide elections, but rather we the people should. But then you can just commit fraud and get away with it. Who else can appeal to other than a judge? Yeah, so you're onto something here, Aaron. So what we're talking about is a judge can issue a ruling in an election case. They can find the different rules are unconstitutional. But what we're seeing with the Trump team is they're not just going to the judges. The alternate escape hatch is that the legal claims and the people even can demand some action from their legislature, which is the body in your government that is responsible for officially nominating and submitting your electoral votes for your state. So if the legislature wants to, respond to the will of the people, if in your home state, in your locality, if there's enough political willpower in order to convince them to make some changes, they have the constitutional authority to do that. Now, I don't know how wise that is, because it would certainly look like they are sort of disenfranchising people if the premise is accurate that Joe Biden did in fact get the majority of the votes. If that is not accurate, if the premise is false there, if in reality, even though the numbers show that Joe Biden has more votes, if the reality is that the majority of those votes were fraudulent, or the margin that puts him over, let's say that Joe Biden has 51% to Trump's 49%. Well, under that scenario, if you disenfranchise 51% of the voters, that's going to be a problem for you politically. And so no legislature is going to want to do that. That's provided that those 51% of the population in your locality, presuming that they are all legitimate votes. But if those, say 2%, 3% of those votes were unlawful, they were fraudulent, they were not signature verified, they were submitted online, whatever, then the real numbers would be sort of a 51% for Trump and a 49 or 48% for Biden. And if that is the true underlying nature of the electorate, and the legislature is responding to that and not the fraudulent version of it, then you would see that maybe there is enough willpower there, and now they're not taking back the election. They're not reversing the election or instituting a coup or anything like that. They're actually just doing the will of the people. That's the argument for it. But thus far, the courts haven't found that that is the case. They're not saying that the premise, there's not enough evidence that that premise is invalid. In other words, the premise that Joe Biden is in fact illegitimate. They're just not seeing that yet. All right, we have Lee with another super chat who says, I may have missed this as I just began watching your show. What happened with the order from SCOTUS to segregate ballots that came after November 3rd in Pennsylvania? So, that is a different case, Lee. And that one was, I think it was the Pennsylvania Democratic Party versus Bukvar. And I think that one is still in flux. I'll have an update on that one tomorrow. There are so many cases now in front of the Supreme Court that it's sort of hard to keep track of them all. This one, though, I think is still knocking on the door. So I kind of want to do an update. I want to see when the dust settles, which ones are still standing, and that is one of them. As a quick refresher, this was where Judge Alito came back and said any votes that come in after November 3rd have to be segregated out into a different bucket because they may be unconstitutional because the Pennsylvania Supreme Court changed the rules at the last minute. Good question, Eileen. We'll have some more information for you on that one for sure. There's going to be a lot of Supreme Court talk for the foreseeable future. We have Miss America Mom 89 says, couldn't they have used fruit of the poisonous tree for the Flynn case if it wasn't pardoned? So fruit of the poisonous tree, I'd have to dive back into the specifics on the Flynn case, but yeah, largely I think that's pretty on point. So in the Flynn case, the quick and dirty of it is they used this fake dossier in order to go get evidence about some people in the Trump administration or the transition team. And they were basically swooping up all of these conversations that were occurring between General Flynn and some other foreign diplomats. A lot of these foreign conversations are captured as part of our dragnet of intelligence. They just gobble up everything. And the sensitive individuals like Mike Flynn are what are called masked, meaning their identities are protected because there's no warrant to go investigate them. They're a U.S. citizen, and this international surveillance should not capture in its net U.S. Citizens that have not been found to have no right to privacy. General Flynn still has a right to privacy. So the argument here was that the underlying dossier that authorized his communications to be gobbled up was fraudulent, and therefore all of that other conversation, all of that other material should be dismissed or irrelevant. And so I can see the connection. I can see the chain there, and I think there's a good argument there. But again, the Flynn case was not something that I spent a ton of time diving into the details on, but the theory is the same. General Flynn, a lot of that was happening before this program was even a thing. So had it been something going on today, we would have covered it, certainly. Very interesting case. All right, another one from Rolly Murray, who says, Texas could, however, divide itself into 5 states, a privilege given to it as a unique condition of its annexation to the Union in 1845. Whoa. That's a fun fact of the day. I did not have any idea that was a thing. Very interesting. Very, very interesting. Thanks, Rolly. Appreciate that. We have Kenneth Fielder, who says, hi. Hey, Kenneth. Good to see you here, my friend. We have Claire DeLuna, who says, why did Texas file this by themselves? Because they wanted to be the Lone Star, like the channel. It helps the algorithm. Thanks, Claire DeLuna. I appreciate that. And she's right. It does help. This was one of those things. I thought that those like buttons were just to make you feel good so that when you didn't like something I say that you could kind of smash the down button. Hope you don't do that, but it does help. I was talking to Miss Faith about it, and we're like, wow, that video got more views and it's got more likes. So I think it actually does something, and I appreciate you recommending and suggesting to hit that button. Thanks, Claire. We have Andrew Borth, who says, repeat the message about peaceful resolution, please. A lot of this is why we have a Second Amendment and Civil War comments. Repeat the message about peaceful resolution, please. So I've been saying this for a long time. He's talking about, why we have a Second Amendment and Civil War comments. I'm not a fan of any of that. I do not believe that this is going to be resolved by threatening, the Second Amendment, or by taking up arms, or by joining, militias, or breaking the country apart, or seceding, or any of those things. I just don't think that is the answer. I mean, look, the United States, we've been doing elections for a long time. The country has been through a lot. We have gone through, everything. We had a civil war, literally a civil war here. Remember that? And we kept it together. We were able to keep it together and keep the country on track. And the best way that we can make our nation stronger is to fix the problems. It's not to kill each other. It's not to fight. It's not to break off and go to a different country. It's to fix it. And the way to do that, I think, is by having good conversations with other people about what the solutions look like, and then, maybe getting a little bit more involved in your political life. Most of the country is still largely uninvolved in politics, which is kind of crazy because it literally impacts their life, but people they want to kind of unplug from this stuff, and for good reason. It's very messy. It's very, it's passion invoking. I mean, people get really hot about this stuff to the point where they want to call out the Second Amendment. They want, to issue a call to arms. But that's not how we solve anything. I think that does more harm to the movement than good. And what we want as a country are people to get more involved. I know politics can be hard. It's kind of a blood sport. It can be very, very, very grating for many people. But that's why we have such a great country. It's why we live in America. It's why we have all the great things that we have. It's because people take an active role in their government. It's self-governance. We have to be involved from time to time. This is one of those times where we got to really lean on our elected individuals and say, look, election integrity, free, fair, fast elections are what we want. We want security and integrity in our system of government, because if we don't have that, everything else fails. We can't talk about these other issues. We can't talk about, universal basic income or healthcare or foreign policy or global warming or abortion or any of those things. If we can't vote correctly, if we can't be sure that the people we elect are actually the people we voted for, everything else becomes irrelevant. It all becomes moot. And what we need to do, in my mind, is focus local, make it a cause, if you're involved in your local politics, to demand that you want election accountability from all candidates moving forward. That is the right way to do it. Fighting, threatening, burning down buildings, that is not the solution. That will set the movement back for a while. All right, let's go on over to Sammy D. He says the Constitution is a contract between the states. They entered into a Constitution knowing how the other states would choose their electors. Dr. Sammy D. You're right, and I think that's going to be the argument that you're going to see from the states, that if one state is allowing a bunch of fraudulent votes to come in, it dilutes that state's electoral votes. So it would just be like, if I got one vote and you got 2 votes, my vote would be 1/2 as valuable as yours. Same with Texas, same with these other states. If Texas is going for Donald Trump, but these other states are going for Joe Biden, and those were fraudulent Joe Biden states, it's taking away from Texas's votes. Texas's votes, if Joe Biden wins, their votes don't really matter, right? Because their candidate didn't win. So it's important that all the votes count, and I think that's the underlying foundation of the argument. It's under the equal protection. The laws protect everybody equally. All right, we have another question. Do you think Melissa Carone might have a good defamation case against SNL? So Lava Java Lava, thanks for chiming in here. This Melissa Carone, if you don't remember her, I think she was the one who was in the Michigan legislative hearing. She was the one who was giving it right back to that state legislature. She was a legislator, and she said, hey, I signed a document under the penalty of perjury. I could go to prison for that. Did you? And she did this. Did you? Gave him that little, a little bit of that sassy face. I think that it was even a Twitter hashtag that was flying around on the internet. So I did not see the case that she would potentially have based on SNL. I don't know what that skit was. I didn't see that. But it's a good question. She should contact Lin Wood. I think he's a defamation lawyer. See what he has to say about it. Defamation is a weird beast. If they could make the claim in defense of a defamation lawsuit that she sort of put herself in the spotlight, in the limelight. She was seeking public attention, and that none of this stuff was done with any actual malice, and that the defamation lawsuits should fail. But I didn't see it, so it's hard for me to comment. But good to see you, Lava Java. Thanks for being a part of the program and for the super chat. All right, we have Durago Sullivan, who says law didn't matter in Flynn's case. Sullivan and the D.C. appeals court went after him regardless. Classic political prosecution. I totally agree with that. I went back and we did cover some of the Flynn stuff where we were literally looking at the transcript between him and that Russian ambassador, I think it was, Kislyak. And Kislyak they weren't even talking about anything consequential. Essentially what happened was after the 2016 election, Donald Trump was, transitioning into office. They were all angry about the Russians and the Russian collusion and all that stuff. So the Obama administration started imposing these sanctions on the Russians for supposedly interfering with our election. And that was the basis for gobbling up all the conversations. And so what happened was now General Flynn is in the crosshairs because of the Obama administration, and that just carried over. But the conversation between Flynn and Kislyak was very benign. Nothing really, in my mind, of any consequence, but they prosecuted him anyways. Pretty ridiculous. We have Ryan F. who says, do you actually use those monitors for anything? And yeah, I do actually. So let me give you a quick show. So you can see here, if I pull that up, see that is my Adobe Audition. That is where I will go and clip out the rest of the show. So I'll take the video and I'll clip out the audio, and I'll just upload the audio only for the podcast. So I use that for that. And then I have, let's see, anything else that I can pop up back over there. This is, well, you can't see that, but yeah, that's where I upload. That's Buzzsprout, where we upload and host the podcast. So basically what I do here on the program is I just record the show right here, flip around. I've got 4 monitors that I can do my my post-show production wizardry over there. So it's pretty convenient, and it's I don't have to make a lot of adjustments on the program. I can just come sit down here, got a little workstation, got a nice little studio. It's very convenient. Highly recommended if you do any content creation. That comes over from Ryan F. Thanks, Ryan. Appreciate that. On over to Denise Rosseliak. Says this transcends DACA or delegitimizes SCOTUS. So thanks, Denise. Transcends DACA and delegitimizes SCOTUS. We'll move over. We've got one from Robin Meeks who says, this isn't even close to being over. Pay attention to President Trump's demeanor. He does not appear to be worried. I'm sure he has his trump card in play, and we are just not privy yet. Keep up the great work from Robin Meeks. Thanks, Robin. I appreciate that. Thanks for being a part of the program and for that super chat. Yeah, it is weird. I have been watching Trump a little bit. He doesn't seem particularly perturbed at all. Just kind of like yesterday, I think he said, pay attention in these next coming days because there's going to be some big things happening. I think that was exactly what he said. Big things coming or big things happening. And he just kind of is going about his business. He's still got some time as president. Remember, he's got over a month. Inauguration day doesn't happen until January 20th. So there is a lot of additional room here. But we are getting closer to that January 6th deadline. So if they are going to be making some moves, should be happening soon. Strange that Dominion execs seem to have gone underground. Your thoughts? So this is from Mr. Bob for you. He says, strange that Dominion execs seem to have gone underground. My thoughts are on this, and I've commented on this before. It's the right thing for them to be doing. I mean, it's suspicious as hell for the rest of us out here. I think that they should be held accountable. I think that Personally, I think that the public should have access to essentially everything that they do. I mean, it's a public election. Why don't we see the source code? Why don't we see how they operate? Why is everything proprietary, hidden, all the contract? I mean, they don't have to answer any questions. They're literally running our elections and they don't have to answer questions. That's insane. But if I were their attorney, you better believe I'd be telling them, listen, man, I'm going to send you down to South America. Take the whole team. You're all going down there. Find a hotel. You're not coming out here until January 21st. I don't want to hear from you. Don't even send me an email. I don't even want to know where you are. That would be the argument. You go into a bunker and you do not come out, because if they come out, they're going to get asked questions. And there's probably a lot of good questions that are going to be asked of them that they don't want to answer. So the only other, mechanism there is to exercise your right to remain silent. You've got a right to not talk to any of these people. You can plead the fifth. You can go into, you can say, I refuse to answer those questions on the basis of the Fifth Amendment and my right to not self-incriminate myself, right? And that's essentially what they're doing. It's probably the right move for them. Not good for the rest of us, but good for them. We have Eileen, who says, can you speak on the Senate report regarding Hunter? Would findings of the financial transactions between the CCP and the Biden family weigh in on a Biden presidency? So I have not seen, if there's a new report there, Eileen, I haven't seen it. I did read some of the old Senate report a while ago. I mean, this was well before the election, so I don't remember most of it offhand. We did cover a lot of the Hunter Biden stuff on this program. I mean, the Hunter stuff specifically, I don't know how much weight that should carry in undermining the Joe Biden presidency. If he has a drug problem, a sex problem, a gambling problem, a money problem, whatever that is, that's him. I have empathy for people in those positions. I understand, those positions. And even when we were covering the Hunter Biden stuff, I was trying not to dogpile on the guy. He's obviously got a lot of problems, and just because he's got a lot of personal problems doesn't necessarily implicate the rest of America until it does. When it does, then it becomes a problem, and it's looking like it had become a problem in terms of Burisma and some of these other deals with the big guy and so on. So, anything that spills over into that, I would say, territory, anything that implicates Joe Biden is certainly a concern for the country. But that all kind of dropped as soon as the election was over. That was all October surprise pre-election stuff. And so right now, my understanding is that John Durham has been appointed as a special prosecutor to carry over into the next administration. Whether he's going to continue to pursue any of that, any investigation into any of that stuff, we don't know. But we'll continue to follow it, of course. If that does change, we'll be talking about it here, certainly. All right, Dolt McAfee says, do you think that the Supreme Court rejected the case today because the Texas case was filed and it's a bigger case? It is a bigger case, and it does look like there are a lot of other states who are joining that. So I think that could be one reason, and that might be the reason why they didn't give a dissent or they didn't give any explanation for it. They may have just said, look, all right, Texas got filed today. We're going to get rid of the Pennsylvania case because this new Texas case includes Pennsylvania, so we don't need to deal with two competing cases out of Pennsylvania. And this may be, think about some of this, right? The Supreme Court is not sitting there in a bubble isolated from the rest of the legal world. There are people communicating up and down all of the verticals throughout the country. I'm talking about verticals from the legislatures, from the voters to the legislatures, all the way up and down the different chain of command for the executive branches. Same with the judicial branch, from the lower level courts up to the appeals courts, through the circuit courts, up to the Supreme Court. There are people talking about how this is going to be solved. And I'm going to guess. Now, I've never been behind closed doors with the Supreme Court judges. I'd love to one day. That'd be an amazing experience. However, I have not been there, so I don't know what happens behind those closed doors. And my guess is that they're talking about which cases to handle, how they want to resolve this, and there are some ideas about how they're going to be dividing when these issues come in front of the court. So those conversations, I would imagine, are taking place at a very, very, very rapid speed right now. And one of the reasons why they may have not wanted to provide any other information on the Kelly case is because they're going to address it in another case. We have another question here from Jesper Larson. Says, hi from Denmark. I really enjoy watching your channel. It's very interesting to hear about these cases because I don't hear about it in the media. Yeah, thanks, Jesper. That's kind of what we're trying to do here. You hear a lot of the headlines, you hear a lot of the snippets in the media. I call it copy-paste journalism. One person comes out with a story, and then you see it kind of spammed across the internet on all the other different platforms. It's the same thing with a little change of a headline. It's very topical, not very in-depth, not a lot of analysis there. And so we wanted to add to the conversation. You know, we kind of treat this show like a dinner table. I'm inviting you over for dinner. Let's talk about politics, sort of like, you know, like a good, wholesome, civic conversation about the issues that are impacting our lives. And I appreciate to hear that you're from Denmark. I mean, it's amazing. And when I hear things like that, it's crazy. You know, it's crazy to me how this is all working these days. And this show is very, you know, it's very new. It's very early in our development of what this is. And so it continues to evolve, and it's sort of growing with you and the community. And it's a weird experience. I'm so grateful for it, but I appreciate the feedback. I mean, I appreciate you saying that you're watching in Denmark and you appreciate the analysis. So thank you for that, Jesper. And thanks for being here. We have another one from Andrew Borth, who says, thanks for your comments. I am for more people to be actively involved in politics from all parties, even extremes. Yeah, we want more of that. We want more engagement. I think the worst thing that we can do is tell everybody to sit down and shut up. And to do it in two different ways. One is to say, sit down and shut up, you're a conspiracy theorist. The other way to do it is to say, you can't talk about these issues anymore in the interest of unity, in the interest of democracy, in the interest of the republic. You can't continue to talk about this stuff because we got to come together and heal. It's two different arguments. I think both are not genuine. You know, both have ulterior motives there. They don't want you to talk about these issues because these issues harm them. And that's just too dang bad. You know, the worst thing that we can do is tell people who have concerns about the election and about how our government runs is that they have no valid claims, because all it's going to do is going to put them into a corner. They're going to be very angry for the next 4 years, and the country's going to be worse off. So we're going to continue to have these conversations, and I appreciate that you're here, Andrew. We have Medic for the USA says, what's law on running for vice president and still holding a seat somewhere else in the government? So I think once you become the vice president, you don't get to be the senator anymore. But Kamala Harris is not the vice president yet. And so, well, you know, many people were speculating that she's holding on to her Senate seat because she thinks she's going to lose the presidential election. You know, I think that's a fun concept, but I don't think that's the case. I think it's probably a practical reasoning. In other words, she's on the Senate Judiciary Committee, or I think she's on both the Senate Judiciary Committee and the Senate Intelligence Committee, which means she gets briefings, she gets updates, she gets a lot of information that she's not going to get when she's over in the vice presidency, if that ends up happening. And right now she's got a lot of information, right? And Trump and his team have not been particularly forthcoming in their transition, or I would say, you know, accommodating in their transition process. So she probably just wants access to the data. I think it's probably something as benign as that, but who knows? We will see. We have Jill Stein with a nice super chat. No question. Thanks. Is that Jill? That's a Jay Stein. Thanks, Jay, for the super chat. Appreciate you being here. And we have another from Larry Robinson, who says, Trump show you the fraud, how bad the Democrat Communist Party is. So Trump showed you the fraud about how bad the Democratic Party is. And now you will have to live in a country that looks like Venezuela. Democrat out there, please take Senate in Georgia. The end will be short and sweet. All right, Larry, thank you for that. Thanks for the super chat. Very generous of you. I appreciate the support. And yeah, Georgia, the Senate seats in Georgia, those are going to be big. Pretty important. What's going to happen there? Seen a lot of individuals out there, some other lawyers out there behind the microphone telling people don't vote in Georgia. Not a particularly good idea in my mind. I know you don't like the election. I know you think it's rigged. I have a lot of problems with the election myself too there, especially in Georgia, especially with Brad Raffensperger. We've been covering it a lot, but just because we have some issues with the voting process doesn't mean that you just don't vote. We got to fix the system. We got to go in, we got to keep playing that game and fix it, not just abandon it. Because if you abandon it, you're going to lose your claims. It's going to be a blowout. Even if there is fraud, it's going to be so far gone that there's not going to be any mechanism to do anything about it. So I would really encourage people to go vote in that election if you are interested in doing so. All right, we have Jamal Boussanet, our friend from France. He says, my ankle monitor is mad itchy and I want to cut it off. You got my back if I get in trouble? Sure do, Jamal. That's what we do here. Also, SCOTUS set a December 10 deadline for response from all states. Thanks, Jamal. Jamal Boussanet in the house. And he is giving us some good news here. On December 10th, we're going to have a new deadline. So that is going to be on Thursday, which unfortunately I will not be here for the show. Ugh. Kills me. All right, so let's go on over back to D. Marlowe. He says, I studied the fleeting and escaping review exception in law school in the 80s. Another attorney tells me he remembers it. Fleeting or escaping review. Yeah, it's not ringing a bell for me. Law school for me I finished in 2012, so it's been a little while. So there are some of those little, some of those things are kind of dusty in those nooks and crannies back there. I don't remember that one, but I will take a look. Thanks, D. Marlowe. And didn't realize you went to law school, but I'm glad you did. Thanks for sharing that. We have another one from Claire DeLuna, who says the Senate's Hunter Biden report got dropped a bit ago today. Seems like everyone in the Biden family is named as shell companies. I haven't read it yet. Ooh, okay, so this is a new one. I did read a prior one that was, I think, released in October before the election. Have not seen the new one, so that will be juicy. I'm going to take a look at that. Thanks for notifying us of that, Claire. We go over to Kenneth Fielder. He says the judges who have made judgments without due process are crippling the state and the district level courts. I actually do agree with that. I think that I would have liked to have seen more courts and more judges just give a little bit more. I would like to see more discovery. I would like the people who are largely contesting these things I would like to see them get a little bit more information. Let us go do some more forensic audits. Let's do a bigger audit. In Kelly Ward's case here in Arizona, the original audit was 100 ballots. That's all they gave her. We like bigger audits than that. All right, we have another one from Kenneth Slayer, who says, if this slide will go, says, have you seen any confirmation that Dominion was bought by the PRC through a Swiss bank? So Kenneth, no, I have not seen that. I've seen those headlines flying around. I know that I think Tucker Carlson just had a big expose last night on some Democratic candidates or even elected politicians who have sort of been infiltrated by the Chinese government or spies or something to that effect. I haven't spent a lot of time on it, but there's a lot of these claims flying around that Dominion was bought by so-and-so and it's a shell company for so-and-so and all, and a lot of those things, if it's too sort of messy, if I have to go from A to W, A, B, C, W, it's hard for me to condense that down in a way that makes sense for the show. Honestly, it's just, it's too much out there. And when stuff is that complicated, it's easy to connect dots in kind of in any way you want them to. And sometimes some of that feels like that. So I just haven't seen any formal documents or formal evidence that supports that. But if somebody can show me that there's a contract or some sort of a transfer or there's an SEC filing or something where some shell company that's a hand of the PRC or the CCP is, literally buying a piece of an election company, that would be compelling. All right, we have Dirk Kessler, who says, I'm declaring myself as president-elect. A lot of people have. I think one of my friends on Twitter declared himself the president-elect of the moon because apparently you can just declare yourself president-elect of anything these days. He says, I'm declaring myself president-elect. The AP Aunt Patty called my election in my favor. Can I announce you as my attorney general? Yes, Dirk. Very funny. Yeah, yes, sure. Happy to be your attorney general. Aunt Patty sounds like a very credible source. Probably a very nice woman. And sounds like she's called the election quickly and in your favor. Congratulations on your new position. Happy that you're here and a part of the program. We have another one from Wolfgang Deo. It says, I think there is a difference, warn/threat, between leads to civil war, and this is why we have a Second Amendment, just helping to show the contention. So a difference between warning and threatening and then actually going to civil war. I think Wolfgang is saying that there is a difference there. I get that. I just don't, even the threat, what good is a threat if it's an empty threat? Everybody knows it's just an empty threat. So I don't know that there's a lot of value to something like that, but I understand your point. Thanks, Wolfgang. Appreciate that. We're going to swap over. We've got Agent Grin in the house. Says, with Powell's accusations of foreign bribes and influence through the CCP in Germany affecting the U.S. elections, how likely, if proven, will we see charges of sedition, treason, and how far down can those trickle down under conspiracy? Whoa, good question, Agent Grin. That is a meaty question. So, quite frankly, I don't think that we're going to see any of those types of charges, any sedition, any treason charges, unless we see more evidence. If Sidney Powell comes out and she's got some names and dates and she's got some concrete evidence of text messages or money transfers or emails back and forth or something to that effect, maybe, but I don't see it coming. I know a lot of people probably don't like that news, but From what we're seeing right now, we're not seeing almost any activity from the FBI. That's not true. Yesterday, we talked about a case in Maricopa County out in Fountain Hills, Arizona, where they, the day after the election on November 3rd, issued a warrant to go seize a bunch of data from some individual who stole the data from our Arizona Secretary of State. Right, and the FBI is involved in that. They're, of course, not commenting about it. So the FBI could be doing, some more investigations. I tend to think that the Department of Justice, the Attorney General, William Barr, not particularly interested in this type of stuff. Now, there's been some rumblings back and forth that, originally he said he hasn't seen any strong evidence of that. Then he went over to the White House and had a meeting with Trump. Then he came back out and kind of walked that back a little bit. But we're just not, we're not seeing the type of activity that you would expect to see from our intelligence agencies or from our Department of Justice or from a lot of our local justice operations that are doing a deep dive into any of this stuff. So the idea that they're going to go find somebody and bring them up on charges, I just don't think it's realistic. If they find somebody, then that will all change. But so far, we haven't seen a name. All right, we have Eddie Oliver who says, I was born in Arizona and moved to Texas because of the influx of peeps from California. Run for your lives. Yeah, they just keep coming and coming and coming. We go over to MW with the super chat. Thanks, MW. Appreciate it. We have Lord Joseph who says, so in your opinion, what level of evidence do you think would be required for a serious look at this alleged fraud? So, it's a good question. I mean, in my mind, a lot of this evidence has been compelling enough. If I were a judge, I would have moved this stuff forward. I would have said, yep, you got discovery. You've got, Dominion. Give them access to your machines, all these different Secretary of States, open up your database. Let me see your records, let them dig through whatever they want. You're public servants. You're in the public sphere. You are responsible for running elections that govern the rest of the public. The public has a vested interest in seeing what you do and how you do it. And you will, in my court, give them access to that. It's serious enough for me. And I would say, listen, Democrats, by the way, you have a vested interest in making sure that the rest of the public feels heard and feels like this election is legitimate. Because if it's not, if the public doesn't think that this was an authentic presidency, that is a problem for you. That's a problem for you, Democrats, because you're not going to get anything done. You're going to be living in the shadow of a fraudulent election, whether it's true or not, unless you give the people something that's going to satiate their demand for information. That would be my argument. So I think it's enough. Now, for the courts, I don't know. I don't know what they're going to look at as enough evidence of fraud. I think that it may be sort of missing the mark on the question just a little bit. I think that really what they're more interested in hearing about is what we saw in the Texas case. They're less interested in hearing that Dominion was created by Hugo Chavez in Venezuela 20 years ago. Okay, that's an interesting story. Turn that into a Jason Bourne movie, but that doesn't have any relevance today. Here, the idea that the executive branch was taking power away from the legislature, it's a whole different argument. That's a constitutional problem. That is a separation of powers problem. It's an equal protection. It's a due process issue. So now the Supreme Court, I think, would be much more inclined to hear an argument like that. And there's a lot of evidence of that, as we just read through today in Texas. Thanks, Lord Joseph. Appreciate your super chat and for being here. We have Jason Breeson who says, if Trump doesn't succeed, but then wins in 2024, can he serve 2 terms starting then or only 1 since he already served 1? So Jason, good question. Only 1 term. He can't get a total of 3 terms if he got elected again in 2024. I think he's going to be 78 or something like that. So he would only have 1 more term. And I'm not sure that has happened in American history. Has that happened in American history? Am I wrong on that? I think Teddy Roosevelt tried it. I think he lost, ran again as he formed a third party, ran as the Bull Moose Party, something like that. I'm really, really digging deep in there. Don't know if that's right, but it would only be 1 term. Thanks, Jason. We have Brian Hack who says, sorry to toot my horn here, but I do have a video on my channel that's, quote, change, share, leave the world about space. Might be interesting since I give a kind of computer science look at modeling people. A hint. Awesome. Yeah. So check that out. Brian Hack has a video on his channel. Go check his channel out. I would love to do that. And I love that type of stuff, might be interesting. Yeah. Very cool. So thanks, Brian. Go check out his channel. I think that would be very interesting. I will do so myself. We have another question comes in from Funeral. Says, real question. Judges have told the Trump legal team that there is no evidence of real fraud on what Trump's team is saying on TV differs from what is said in court. Please explain how this isn't a stunt. So I think what you're saying is, well, I think what you're asking is, why is the difference? Why is his team making different arguments in court versus in front of the legislature? And the simple answer is because one is a court, one is a legislature. So there's different powers and different remedies that they have, and you want to appeal to your audience. You want to make a claim to the people that you're speaking to. So in a court, they have the authority to do certain things, whereas the legislature has the authority to do different things. And here, what Rudy Giuliani and they're talking about is about telling the legislature to go out there and claw back a lot of this power that they have delegated over the years over into the executive branch. They're saying, take that back. It's yours under the Constitution. Go look at it. You have the authority to run the elections however you want to. You have the ability to nominate your electors in whatever fashion you think is appropriate. So you take that back. In front of the courts, they're making different arguments. They're making constitutional arguments. They're making, the discovery demands. They want access to go do forensic investigations and things. The court has certain powers the legislature doesn't have. And so you are going to see a mismatch. It's like, it's like speaking to a group of men or speaking to a group of women. You're going to, the conversation is probably going to change a little bit based on the audience, or it's a bad example, but a high school group of kids versus a college group of kids. Two different audiences, two different messages, two different remedies, two different mechanisms for them to implement what you're asking them to do. That's why you're going to see a mismatch. Now, some people want to say it's a stunt. There's a part of that there. What they're doing in front of the legislature wouldn't necessarily fly in front of the courts because it's a different audience. There's different rules. There's different standards. So it's not unusual, but you also have to understand that what's happening in front of the legislatures is taking place in the court of public opinion, not in a court of law. So they are trying to be more persuasive. They are trying to rally public support behind their efforts to change the course of the election, which is not really what's happening in court. In court, they're just appealing to the judges, not the general population. Good question, though, Funeral. I understand your point. All right, we have a couple very nice super chats with no questions that Miss Faith clipped for us from Steve. We've got Allison Franks. We have Jeff Campbell. Thank you all three very much appreciate the support. Very generous of you. Thanks for being here. Another question from Kelly Alex, who says, if the legislatures contest the results in the House, can't they vote for who they want? I thought you talked about this last night. So yeah, Kelly. So we're talking about two different things here, talking about two different legislatures. So if you want to talk about your local state legislature, yes, theoretically, provided that the states are not already certified, I think there's still arguments that they could decertify their states if they wanted to. I'm not sure, though, that they would be able to succeed there, at least in time, because they would get sued to oblivion. Let's say, for example, in Pennsylvania, there's a Doug Mastriano in Pennsylvania who is very active on Twitter saying, we don't think this was a legitimate election. We're going to reverse course on this thing. If he were to go rally the support, call a special session, go in and with a majority of the votes, change how this all works in Pennsylvania, he and all of those different changes would get sued into oblivion because Pennsylvania has already been certified and they're just going to say the certification process can't be undone. It's going to be litigation for, forever until it becomes moot or is resolved. And that would be difficult. But if you go into the House of Representatives, which is the federal House, which is basically our federal legislature, and they want to object to the electoral votes being cast. So now, let's say Pennsylvania, okay, they don't file a lawsuit. The individual state legislature doesn't go and modify the underlying electoral votes. But when those votes are cast in the United States House of Representatives, somebody objects to that. So Ted Cruz says, nope, listen, I believe in that Kelly versus Pennsylvania case. Supreme Court declined jurisdiction over it, but I still have a problem with your votes, Pennsylvania. And so I'm going to partner with somebody in the House of Representatives who is, I think, already on record as saying he's going to object to some votes. I don't know if that's still accurate, but there was somebody in the House who was saying that. If they are able to do that and they object to Pennsylvania's votes, and somebody else does that for another state, and Biden's total electoral votes go below 270 votes, then you have what's called a contingent election. Then at that point, every representative in the House or every state gets one vote. the Republicans have more states than the Democrats do. So the House would elect the next president, which of course would be Donald Trump, if that were the case. So I think there's kind of two different ways to go through it. I know it's very confusing, but that's essentially how they both work. All right. Rolly Murray again says Governor Gavin Newsom will pick California new senator. If she quit now, that senator would have time on the new class, but face re-election in 2022 either way. Interesting. Okay, so that's interesting. So there's another reason from Rolly as to why this she may have another basis for not giving up her Senate seat so quickly. If she quit now, that senator would have time on the new class, but face re-election in 2022 either way. Okay, so maybe there's some other reasons for it. We have OG2 who says, just started a change.org position to the Ohio Attorney General Paxton to join Texas. Can't hurt, right? Could petitioning the AG state to state generate pressure at all? Yeah, I absolutely think so. Absolutely think so. I think that there's a lot there, and we've spoken about this at length here, about this legitimacy. You know, Donald Trump has his team of attorneys, but he needs some other legitimacy from some other aspects of the government. He needs other people to chime in and get involved. The FBI, the DOJ, he needs different states. He's got 10 senators now, plus Ted Cruz. If you can have other branches of government come and support his claim, including state AGs, state legislatures, you know, other people with a lot of influence, that might give him some additional legitimacy. And I think that that is largely what they were trying to do with these public hearings. They want to rally support and show the courts, look, this is not over yet. The people are not just acquiescing and saying, we just trust the election. Hello, Joe Biden. That's not the situation at all. They are saying that, you know, the public is demanding action, and they're leaning on the courts to come out and clarify some things. But the courts thus far have not succumbed to that pressure, as it were. We have Truman HW, who has another super chat. Let's swap on over here, who says he had Durham intended a real investigation, he'd have charged Klein-Smith maximally to compel cooperation. Instead, the court allows him to mitigate intent in his plea, no mea culpa, and 180 days max. Yeah, so I think he's talking about the Durham investigation. There was a sort of a kind of a weak plea deal that came out of that. It didn't seem like it had much teeth to it. What he's talking about here is using sort of one set of criminal charges against one person to encourage them to cooperate with you in exchange for a reduced charge. And here Truman HW is saying that in Klein-Smith's case, they could have gotten more information out of him, but they didn't. We go over, we have Jay Sim, who has a super chat for us. No question, but thank you for that. Says, keep it up. Appreciate that. We have MW, who says, any inside opinion into the astounding increase in military flights is, according to Monkey Works on YouTube, never before seen, and his opinion is it's not good. Martial law, insurrection, or even war. Wow. No, I have not seen that. An increase in military flights. You know, I do know that there are those websites that you can see all the flights in the air, and I think that even includes military flights and even some sort of like, you know, secret flights and things like that. I'm not a pilot, don't have a lot of air experience in terms of any of that stuff, but very interesting. So maybe take a look over there if you're curious as what's going on with that. Look over at Monkey Works on YouTube. Thanks, MW, for flagging that for us. Very curious, very curious. I hope it's not anything like martial law. We don't want that. All right, Rolly Murray, who says, Stephen Grover Cleveland was an American politician and lawyer who was the 22nd and the 24th president of the U.S. I'm learning so much today. Thanks, Rolly. That's awesome. Now that you mention it, I do remember that, but I didn't, Stephen Grover Cleveland. Yeah. 1837 to June 24th, 1908. 22nd and 24th president. How cool. Thanks for that, Rolly. Very, 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 very cool. I'm learning a lot today. I appreciate that, everybody. We have Kenneth Fielder, who says, yes, I believe there was 2 presidents early on. One died in the beginning of the term, thus going to VP. So we got some more information on that. We got Robert Barnes in the house. Oh, we have the big dog in the house, Robert Barnes. He is saying, good job on the elections. Thanks, Robert. Very much appreciate that. If you're not a follower of the Barnes, he's over on kind of everywhere. I'd follow him on Twitter. Very, very good election analysis. Somebody who I think is astute. I've actually heard him speak, and I thought that's pretty dang brilliant. That's pretty good. I never heard that before. So definitely go check him out. He does a lot with Viva Frei. I think they have a live stream a number of times during the week, and they've been covering a lot of the election stuff. So very good channel. You're probably, if you're interested in this channel, you're probably already following them. They have a very big and very good looking channel over there. So go check them out. Viva Frei, Frei, and Robert Barnes. And they're also over on Locals. I actually just joined them on Locals. So you can go check them out. We don't have we might have a page on Locals, but we don't ever use it or post anything over there. But Locals is a private platform. And, a lot of these content creators are sort of moving their stuff off to different platforms out of fear of being canceled and censored. And so Robert Barnes and Viva Frei are over there. Big hat tip to those guys. Love the work. So go check them out as well. All right. We have Kenny C, who says, what's funny is it doesn't matter what platform I'm on. There's no consensus where Biden is the legitimate winner. That should tell you everything. Yeah. I mean, there's a lot of people out there. I have a lot of friends. I actually don't have a lot of friends. I have a handful of friends, let's say. And there are some of them who happen to be pretty left liberal individuals. And even when I'm talking to them about it and I say, come on, admit it, they all go, yeah, we kind of don't really believe that. There's still one friend of mine who's still on pins and needles. I mean, he's more on pins and needles than any of the Trump people. He's waiting for the day that Trump takes this thing back because he just doesn't think it was legitimate. And he's a Democrat and he's thrilled that Joe Biden's in office. So all that is anecdotal, but it is funny. We have another one coming in from Jamie Zaluff, who says, Rob, wouldn't you think the Supreme Court would not want to see socialism as well as their very own court possibly getting packed? Yes, Jamie, I do think that. Remember what happened here, Jamie Zaluff? So what happened is the Supreme Court, as I've talked about, it really leans on legitimacy. If they don't have any legitimacy, they really don't have political power. And so there was a time back during the FDR era, Franklin Delano Roosevelt, where the Supreme Court was 9 and FDR was passing all of this New Deal type of legislation, and the Supreme Court kept knocking down his legislation. So he came back and said, all right, that's fine. You want to knock down my proposals? We're just going to add a bunch of judges to the court. We're going to expand the court. I think he wanted 15 different judges on there. And suddenly there was a switch from the Supreme Court, and they started to uphold all of his new policies. So you can see here that even though the Supreme Court is supposed to be apolitical, non-political, they are, they got to protect themselves just like anybody. Now, the question here would be, if they did find in favor of Donald Trump, well, they're going to be looked at as completely biased, right? It's a 5-3 court technically. I'm sorry, it's a 6-3 court technically. Even though John Roberts largely sides with the left wing of the court, so you can make an argument that's really kind of a 5-4 court. But if they were to find in favor of Donald Trump, they would just be seen as sort of, hysterical sycophants for Donald Trump, and it would really undermine their legitimacy. We saw this back when Roberts was the deciding vote on the Obamacare case. He didn't want, in my mind, my interpretation of that was he did not want to harm Barack Obama, who just got swept into power on this massive tidal wave of support. He had all two houses of Congress and the presidency. And so if the Supreme Court turned around and said, we're going to just destroy your single most important domestic policy, it's going to really undermine the credibility of the court. So in my opinion, I think that John Roberts was doing everything he could to thread the needle on that case and find in a way that was going to support the Obama administration. So you might see something like that here, right? You may see a bunch of textualists and originalists in Roberts, Gorsuch, Alito, and who's the other guy? Oh, Amy Coney Barrett, the brand new one, Amy Coney Barrett. Who is the other guy? Amy Coney Barrett is not a man, as far as I know, and she is, she's new on the court. So between all of those originalists and textualists, they may kind of twist themselves into a pretzel in order to not find in favor of Donald Trump just to secure the court's legitimacy. Now, as somebody who is more in line with those political or those judicial philosophies, I would hope that they would be bigger than that, but you never know. All right, we have Alejandra Villanueva, who says, the headlines keep reading, Supreme Court has rejected Trump's suits. It's hard to navigate what is going on. Can you explain what lawsuits have been rejected and what that means going forward? So Alejandra, that is a great question, and it's such a big one that I cannot possibly answer it on this show. There is a lot of lawsuits. There's probably another one filed as I've been broadcasting tonight. And there's probably going to be another one before I go to sleep tonight. There's just lawsuits out the wazoo. What I would recommend is that you subscribe to this channel because we're covering the ones that really matter. We're covering the ones that I think have the most weight, have the most credibility, the best arguments. And the other ones are just kind of falling by the wayside. So we've probably covered, 20, 25 different lawsuits here. And most of them are gone. And we're just picking up and carrying forward with the ones that are still in process. And so we're going to keep covering them. The quick and dirty of it today is the Kelly case was dismissed out of the Pennsylvania Supreme Court. The Texas versus Pennsylvania, Michigan, Wisconsin, and Georgia, that one's new in the Supreme Court. And according to Jamal Boussanet, the arguments or the responses are due by Thursday. So now we've kind of shifted gears. We're going to be focusing on this big state lawsuit, I think, for the foreseeable future. So it's a good time to subscribe if you have not already done so, Alejandra, and anyone else out there who hasn't quite done so yet. All right, we'll keep going. We've got some more. Miss Faith just keeps clipping them. Thanks, everybody. We're loving the support. I really appreciate it all. We have Hockey D who says, just saying, loving your analysis and praying for Lady Justice. I've never seen society so on edge, including in the 60s. Yeah, it's great. It's great feedback. And I kind of feel it too. I think a lot of people do. Everybody's kind of just waiting a little bit to see what happens. And it's not just the Republicans. It's also the Democrats. And largely, you can kind of feel it in the media. It's like, there's a lot of people who want to talk about this stuff, but they're not talking about it. They're just sort of saying, okay, we're going to move on past this stuff, but they're all sort of keeping their eye on it and talking about it sort of incidentally because they're a little bit nervous. They're all a little bit nervous, I think, as they should be. How do you think SCOTUS will react to the Texas case, please? So I think SCOTUS will... I don't know what they're going to do. It's anybody's guess, but I would really, really hope that they would give us something on it. I want just some sort of guidance from the Supreme Court because I really do have a problem with all these last minute changes to the elections. I think it's really detrimental to the entire country, not just the Democrats, not just the Republicans. But listen, the Republicans are going to figure out how to play this game. They got blindsided this election. They just let the Democrats change the rules at the last minute, and they were caught flat-footed, 100%. But they're going to figure it out. They're going to get back on their feet, and they're going to figure it out. So here's what I do not want. I do not want a country where both political parties are trying to out-fraud one another. The Democrats, fraudulent as hell in 2020. The Republicans, you better get your fraud game up because 2024 is right around the corner, and you need to out-fraud the Democrats. I don't want to live in that country. I don't think that you do either. So what we want to see is some guidance from the Supreme Court. Is this type of stuff okay or not? Can people change the election rules 3 days before the election or not? In October 28th, what is going on here? I'm hoping that there is some guidance on that. But what are they going to do with the Texas case? I don't know. I mean, if I had to speculate, the idea here would be that they would issue a constitutional order saying that any of these changes are extra constitutional. They're outside of the purview. They're ultra virus. They're not allowed to make these changes. Those changes are unlawful. Send it back to the states. Let the states figure out what the remedy is and move on from there. But we'll see if that happens. Well, we're going to move on over to Jazz Irita, who says, just got here. Please recap for 2 minutes, please. Ha, ha, ha. All right, Jazz, you're going to have to rewind this sucker back because we've been going on for quite some time here today, about 2.5 hours. My goodness. All right, so the quick recap. Kelly case dismissed. The Texas case in front of the Supreme Court. That's the one we should be focusing on now. There are apparently response briefs are due by Thursday. So join us for those conversations because we're going to have a lot more to talk about. We have Jenna Ellis apparently is tweeting that SCOTUS still going to hear the PA case. They only rejected the injunctive relief. Is that true, Brian? Brian Overholt is asking that question. And yeah, this question has come up previously. Let's take a quick look back at this order. So you can see here that it says only the application for injunctive relief is denied. It doesn't say anything about the grant of a writ of certiorari or anything like that. This is all the data that we have right now. The application for injunctive relief is denied. But it wasn't just that. There are some other things that were in the underlying application that order doesn't address. So the theory would be that only that portion of the underlying complaint was dismissed. The other part can still move forward. I don't know if that's true yet, because it seems to me that the injunction is necessary in order for the rest of the lawsuit to move forward. Without the injunction, there may not be a need to grant the writ or the petition. So if that's what the court is saying, then they may have denied the whole thing. But we don't know. They gave us a sentence. That's what I'm talking about. Can we get more than a sentence, boys and girls? Can we get a little bit more information? Because we don't know what the heck is going on right now. All right. Brian Overholt says, oh, we already get that one. We have D. Marlowe, who says, if you read their playbook by Saul Alinsky, there's no talking with radical Dems their way or no way. Yeah, there are some of them who are reasonable, but they are far and few between. All right, we have Miss America Mom says, I secretly want to go to SCOTUS so Kavanaugh and Roberts can have their revenge for being called rapist for Joe and Kamala. And that's karma. Yeah, didn't Kamala even call Joe a rapist? Didn't he bring up something about those Tara Reade allegations? And then she joined his campaign. I think that was after she called him also a racist for the busing comments during those debates. So, not a big deal. Kamala just wants to join the ticket of a rapist and a racist. All right, not a big deal, I guess. Another one from Brian Hack, who says, I think the difference of evidence in court legislature is due to the criminal scope. They have no solid proof of a name, but they do have fraud occurring. Yeah, I would agree with that. When you're talking about a crime or a criminal statute or these concepts of conspiracy, you do need more than just these loose allegations. The standard is very high with good reason. For good reason. It's beyond a reasonable doubt. It's the highest standard in the law that we have. So when you're talking about bringing, treason, sedition charges, or anything to that effect, it's high. It's a very high standard, as it should be. We do not want the government to just come in and prosecute you for whatever the hell they want. It's not a good system. It should be high, and we should demand a lot of evidence. And thus far, we just haven't seen it yet. I mean, we've seen a lot of evidence of fraud, no question. I think that standard is lower than the criminal standards. Preponderance of the evidence, it's 51%. If it's more likely than not, I think the case should at least go forward towards the investigatory stages, but we haven't seen a lot of that in the courts yet. If it's a criminal charge, totally different ballgame. Now we're talking about a whole set of different rules. And we just haven't seen anything that I think would amount to that yet. All right. Our last one of the day, we have Jerry Optimist. No question. Just a nice little super chat there with a nice little dancing, singing pair. And that's it, my friends. That's it for the show. I'm so grateful that you joined us today. And I want to remind you before we sign off to hit that subscribe button, because we do go live at this time. Sometimes we don't go this long. Sometimes it's a little bit shorter, but it's the same time, right about the same time every day of the week. I will not be here on Thursday or Friday. It absolutely kills me, but I've been really waiting for this conference for this entire year. I think I signed up for it in January. Coronavirus hit. It got moved from May to, I think, August or October. Coronavirus still going on. Got moved again to this week, and it looks like I'm going to be able to go. So I'm pretty excited about that, but I will not be here on Thursday or Friday. We will be back here next week on Monday to get right back into it. A couple other things. I want to ask you to share the show. It's the best way to help spread the word and invite other people to be a part of the conversation. We have a lot of fun here talking about these issues, and we want to encourage people to come and think through these things, because rather than going out there and getting agitated and irritated and demanding a call to arms, let's talk about these issues. Let's maybe break down some strategies and some arguments that may be useful to you out in the world, and that it may help people think more about our own government and how we govern ourselves, and what kind of society do we want to live in, and what kind of politicians do we want to be in charge. I want to also invite you to come on over to the Discord chat. That's where we talk before and after the show. I put a copy of all the slides in there. There's a copy of my book in there as well. My book is available on Amazon. It's called Beginning to Winning: How to Fight Your Case and Succeed in the Criminal Justice System. That's me. It's got a 9-step plan that we use to help people get things back on track. If they're facing criminal charges, we want to see how we can get things, back on the right path for them. And it's all detailed there. Buy it on Amazon if you want, or just come on the Discord, get it for free. It's right in there. Would love to see what you think about it. Would love a review on Amazon if you go that route. I also want to tell you that my day job, what we do every day here at the R&R Law Group, my team here in Scottsdale, we love to help good people who have been charged with crimes. I don't think that most of these cases are good people. They're just people like you and I who get into a little bit of a bad situation. They need some help to get through the system. We don't want the criminal justice system to wreck their lives. We want to help them get through it, get things back on track. That is the right way a justice system should work, and we are passionate about making that happen. So we'd be honored if you had any referrals or knew anybody that you would entrust to communicate with us, you can send them on over to us. We have free case evaluations. We love what we do. We're very good at it, and we would appreciate your referrals. Other than that, I want to thank Mr. Ma, the moderator. I want to thank Miss Faith, who's in that office behind me, who helps me put the show together. She's outstanding. And I want to thank each and every one of you. Thank you to all the super chats. Thank you to everybody who's been a part of the program. It's very rewarding. I love being here. It's the best part of my day. I'm so grateful for all of your support. So I will see you here tomorrow, same time. It's going to be 4 p.m. on the West Coast, Western time. It's 5 p.m. in Arizona, Mountain time, 6 p.m. Central Standard to my favorite people over there in Texas. And then we have 7 p.m. on the East Coast. So we want to make sure that you join us. So if you haven't, one more time, one more reminder to hit the subscribe button. Give us a thumbs up. Really helps us out. Otherwise, I want to wish you a very, very nice, warm holiday evening. I will see you right back here tomorrow. Have a great night. Bye-bye.